This webinar is looking at key policy decisions of the new administration. And over the past 6 weeks, the president has issued, according to CNN, over 100 executive orders, a number of tariffs, and made a number of statements indicating his intent to do other things. There's been a number of court challenges to these orders and tariffs and other things. So we're going to focus on 4 topics: taxes, economy, and trade, higher education, immigration, energy, and the environment. As part of our broader effort as an academic institution, through this webinar, our faculty presenters will provide accurate information and understanding of these issues. And the viewers will gain knowledge of these issues and how they affect law, society, and our lives. An educational institution is a forum for providing this kind of important information to the public by providing light, not heat, on these issues. Our experts will shed light, not heat, on these important issues. So I'd like to now turn it to my dean colleague at UH, who's the Hobby School, who is co-sponsoring this, Jim Granato, the founding dean of the UH Hobby School of Public Affairs.
Thank you, Dean Baines, and welcome to all of you. This promises to be a very robust set of discussions. Before I proceed discussing those things, I want to mention a little bit about the Hobby School as well. We're relatively new. We've only been around for about 8 years. We feature emphasis on ethics and quantitative analysis. Those are 2 core training methods. And in our short time of our existence, we've moved from being ranked 150th to now 76th, and the trajectory continues to go up. So we're very proud of what we're doing, and we will continue to do so. And before I proceed with introducing the panel, I want to say thank you to Christina Van Arsdell, who is the Director of Continuing Legal Education at the UH Law Center. She has been tireless in helping organize this. And thank you, Christina. I also want to thank Associate Dean Sandra Tennessee and Samantha Martin, who's also Director of Special Events, for assisting in our seminar today. And finally, I want to thank UH Law Center and Hobby School marketing and comm teams for helping put this all together. Now, to our panel. The panelists are going to focus on 3 things. First will be trade policy. The second will be federal income tax policy. And finally, we'll wrap it up with monetary policy. The speakers we have are extremely well qualified to discuss these issues. Each speaker will be getting 15 minutes to talk. And at the end, we'll have another 15 minutes for Q&A from the audience. And then we'll move on to the next panel, which will be on higher education. So let me first introduce our first panelist, who is Dr. Professor Elizabeth Trujillo. She is the Mary Ann and Lawrence E. Faust Professor of Law at the UH Law Center. Her topic is going to be trade policy in a time of transition. Professor Trujillo, the floor is yours.
Thank you very much, Dean Granato, and thank you, Dean Baines, and thank you, Christina and Sandra and Samantha and the marketing team and all the fellow panelists that are here for having me and for this wonderful program. So let me start the share. Let me make sure that it starts through the whole screen here. Okay, there we go. Wonderful. Well, thank you also to our audience for being here on this day. My presentation is going to be on trade policy in a time of transition. And primarily, I'm going to do a brief overview of U.S. trade trends with a focus on North American trade and also trade with China. I'll also put some context into what's happening, talking a little bit about some of the schools of thought around the purpose of trade in light of the current administration and its actions. Relevant U.S. laws that mark recent U.S. trade policy, the North American trade trends, especially in light of the USMCA, and key considerations for moving forward, especially with respect to the USMCA. The growth trends, world trade in general has grown from 25% in the 1960s to about 60% today. Tariff rates have gone down from an average of 40% in the 1940s to an average of 2 to 4%. And since the 1980s, there's been a lot of big changes geopolitically around the world that have impacted trade. The fall of the Soviet Union, the fall of the Berlin Wall and the reintegration of Eastern and Western Europe, Chinese integration into the global economy, and its export-oriented policies after 2001, expansion of the global value chains and outsourcing, but also regional developments, regional integrated supply chains that have outsourced several inputs for products. And the US has transitioned as well into a primarily services economy. Here's a look at tariff rates from 2012 to 2022, for example, and you see that they've been pretty consistent. They've bobbled up and down between 2 and 6 and 5.5, but the really big peak was between in 2019, 2019, right up here, right before 2020, the pandemic, where we had several tariffs that were implemented by the administration at that time. Our top US trading partners. In 2024, US overall trade, US overall trade is 5.3 trillion. And in Mexico is our top trading partner at the moment with $840 billion of trade in goods, 15.8% of US total trade. Canada is top second at 14.3% of total US trade, and China, our third top trading partner, at 10.9%. And I also have numbers up there that show exports versus imports and deficits, and you'll see that the deficit with China is the largest at negative 295.4 billion. I have up there Germany and Japan, which would be our fourth and fifth largest trading partners. So most of the North American trade, more than 1 in 5 cars and light trucks are sold in the US, were manufactured in Canada or Mexico or both. Canada is the largest supplier of crude oil to the United States. In 2024, Canada shipped $98 billion of crude oil to the US, above Mexico's $12 billion. In 2024, the US imported $32 billion in toys, games, sporting goods from China, plus billions in clothing, including $7.9 billion in footwear made in China. And in 2024, the US imported $49 billion in agricultural products from Mexico, including 47% of imported vegetables and 40% of fruits. The US distilled spirits. Mexico and Canada are the second largest importers of US distilled spirits. And these might be actually greatly impacted if Canada puts in place retaliatory tariffs to the United States. So some context, purpose of trade. What are some of the schools of thought? Well, our modern trade system from 1945, after World War II, was really created through the Bretton Woods Agreement in 1945. But even before then, between the wars, we had many economists that were thinking about the purpose of trade. And it's an interesting quote here by John Maynard Keynes, who was already talking about a global era, right? He talked about being in London and could order by telephone, sipping his morning tea in bed, various products from the whole earth and so forth. And so he was already thinking along the lines of what trade how it could benefit the world in terms of expanding products outside their borders and having access to new resources. But also there was this idea that it would maintain and secure world peace. And this was really the idea around the Bretton Woods Agreement, which was also part of the Marshall Plan in reconstructing Europe after World War II. Into the 1980s and 90s, we see a neoliberal school of trade, which really focused on GDP growth, efficient allocation of resources, economic development through trade, a continuation of the idea that trade can help create economic security, could create peace, technology transfer, investment growth, And into the late 90s and into 2000s, we see that trade moves into not only a neoliberal vision, but also a foreign relations vision. So one in which could be to extend diplomacy, building alliances, creating stability, preserving democratic values and freedom. Global institutional frameworks grew at this time. The WTO was born in 1994. The rule of law in international trade law. It enabled the transfer of technologies and knowledge and the huge expansion of regionalism and preferential trade agreements. Into 2020, we see a transition, even before a little bit in before 2020, into sort of the rise of protectionism. So this is where countries started to look inward and think about supply chain resilience and perhaps regionalizing and friendshoring and nearshoring production. And then, of course, there have been several critiques of international trade, particularly the Twale School, which looked at international trade as its form of economic colonialism, pitting the global north against the global south. So this post-liberal era of protectionism that we're living today, which some would call the Neo-McKinley School, really sees trade as a function of increasing government revenue by taxing foreign producers or foreign products. The focus is on trade deficit reduction and increased use of trade tariffs as some form of economic tools, sometimes coercive in their nature, but also to help our trading partners or maybe renegotiate trade terms or think differently about how these tariffs and trade terms and customs are distributed. It's also thought of as a form of government revenue, generating different types of revenue, a response to non-economic national security threats. It's a rise of unilateralism, and it favors domestic production of goods and services. So where do we get the US authority for our trade tariffs? Well, obviously, there's the US Constitution, which provides the most vests in Congress the power to regulate commerce with foreign nations. And we also have delegated authority to the executive branch. Congress has done this to regulate imports, including those that pose a national threat. The president retains some independent constitutional authority to address national security issues. But Article 2 grants the executive branch treaty negotiating power, which have to be approved by 2/3 of the Senate. And Article 6 says that the treaties become the supreme law of the land. There are various trade tools that have been used over the years for trade remedies when there has been a perceived disbalance of tariffs and custom fees on US products. Some have national security concerns at play and some do not. And so the Tariff Act of 1930 is the traditional use of anti-dumping duties and countervailing duties, which try to remedy the dumping of imports at lower market value that might have a negative impact on US productions and products and make it anti-competitive. And same for subsidies, unfairly placed. These types of remedies do not require a finding of national security concerns. In section 201 and 301, here in particular in 201 and 232, which I'll talk about in a moment, here the president must show that in fact there are some national security interests. Now in all of these, but they're economic, they're focused on economic national security interests. So these types of remedies are short-term. They are to adjust a perceived damage to domestic production as a result of the acts of other countries and their lowering prices or dumping duties or subsidies. And they also have to go through an investigation that is initiated through the US Trade Representative. And 301 are tariffs that have to do with unfair trade practices if it would cause a serious harm to US national security. These were very much imposed at the time of in China. So in the 2018-2019, we saw several Section 301 investigations for Chinese practices on technology transfer, intellectual property, and innovation as unreasonable and discriminatory. And some of these tariffs ranged from 7.5% to 25% on approximately $370 billion worth of Chinese imports. Now, some of these tariffs continued on China, the 301 China, into the President Biden's administration. And some of them increased, particularly on electric vehicles, batteries, graphite, critical minerals, medical gloves, face masks, syringes, solar cell products, semiconductors, steel, aluminum, and other commodities. The 232 tariffs, which were the tariffs that were imposed in the 2018-2019 administration, these were the ones that were invoked for the steel and aluminum tariffs. And this is a law, a trade law, that allows the president to adjust imports based on Department of Commerce finding that the articles are being imported into the United States in such quantities or under such circumstances as to threaten to impair national security. The Department of Commerce initiates the investigation, and if it's requested by any U.S. department or agency or an interested party, there are several factors that they have to take into consideration, including domestic production that is needed to project these national defense requirements, domestic capacity to meet those requirements, the availability of human resources and supplies essential to national defense, potential unemployment or loss of skills, investment, these types of things. And in a famous case in 1976 from the Supreme Court, the Algonquin case, it held that Section 232 was based on a non-delegation doctrine which required cabinet-level determination that the imports threaten national security and limits the president's actions to such imports. So recent trade policy actions, where do they fall? Well, the first actions that we see are under the America First trade policy. And this is a trade policy, it says trade policy is a critical component to national security. And we must reduce the trade deficit, review unfair trade practices. And the Secretary of Treasury, in consultation with the Secretary of Commerce and Homeland Security, shall investigate the feasibility of establishing and recommend best methods of designing, building, implementing an external revenue service to collect tariffs, duties, and other trade-related revenues. And so there's going to be a revisitation of all of our tariffs, including those under review of the USMCA. And this includes examining currency manipulation and exchange rates. So in the interest of time, I'll go quickly through some of these and get to some of the concluding thoughts. But some of these executive actions are those that you have been hearing on the news that produce a 25% tariff on all products from Canada, 10% on the energy products from Canada, 25% on all products from Mexico, including energy products, with no de minimis treatment allowed for these. This has been put into effect March 4th. Although as of today, it's been delayed, at least as to Mexico, till April 2nd. We still do not know what will happen with Canada. But the law that was used primarily for these tariffs is under a different law than the ones that I've been discussing, which is the International Economic Powers Act, which I will talk about, Economic Emergency Powers Act, which I'll talk about in a moment. There's also been 20 tariffs put on China on a similar executive order. And this is raising the 10% tariffs that were already placed on China at the beginning of the year to an additional 10%. And the de minimis treatment shall not be in effect vis-a-vis China. So if the shipments are worth less than $800, they will be exempt. So there are other very relevant proclamations that are worth noting, especially the America First investment policy. The IEEPA, or the International Emergency Economics Power Act, is an act that was put into place really under the umbrella of National Emergencies Act. It grants the president extensive power to regulate a variety of economic sanctions and transactions during state of national emergency. The IEEPA was enacted in 1977 by Congress to limit the emergency economic powers that it had delegated to the president under the Trading with the Enemy Act, the TWEA. And the TWEA was originally empowered the president to take control of private property for public use during war time or conflict. It also granted the president lots of power over trade, investment, migration, and communications between U.S. and its enemies. It mostly was contemplated in the times of war. In the 1930s, during the Great Depression, Congress delegated the president discretionary authority to declare states of emergency in peacetime, assuming expansive domestic economic powers. And during World War II, they vested power in the president for seizing property of foreign land as well after a declaration of national emergency. So, President Roosevelt referred to the Depression as such economic crisis and linked it to armed strife. But there were several limits during the 1970s on some of this presidential power, including IEEPA, which the president must communicate to Congress several reasons for exercising such authority. What is the unusual and extraordinary threat, demonstrating that it's connected to national security actions and so forth. So when you compare the two in terms of finding authority to pass these tariffs, excuse me, when you compare the two, the biggest difference is that the president has much more expansive authority, and it's somewhat not clear the extent of that authority under IEEPA to pass certain remedies that affect the economy, particularly though it's been used with respect to sanctions, with conflicts associated with terrorism, human rights violations. The USA Patriot Act, for example, after 9/11 is an example of this. Until now, IEEPA has never been used to impose tariffs on imported products from specific countries or products. And it is not subject to congressional procedural restraints, as the 232 Trade Expansion Act is, and there's no investigation required from cabinet level, as in the 232 safeguards context. So the effect of tariffs really span around the discussions you've been hearing in the news, retaliation by our trading partners and how that might impact our own products. And China has responded that they will impose 10 to 15% on certain US products starting on March 10th, 2025. And they also have already placed some restrictions, investment restrictions on national security grounds for some of our firms, in particularly 10 firms that were targeted, they say, are selling arms to Taiwan. Canada as well will put in 25% tariffs on several of US imports if in fact these tariffs go into effect, including distilled spirits. In Mexico, we're still waiting to hear on that. So some of the risks have been that there could be a risk of rising prices to consumers and inflation. The Peterson Institute says that these tariffs could cost the US consumers a net $1,200 per year. It could raise the cost of inputs needed to produce products, so it will impact supply chains. And the 2018-2019 tariffs, we know, hurt US manufacturing employment, forcing manufacturers to lower prices of exports as a result of the retaliation from other countries. Current tariffs are broader than those in 2018-2019. They also impact intermediate imports. And they can hit a wider range of production inputs, potentially reaching more trading partners. And this can also affect the stability of the markets. There could be some benefits. There could be more investment in the United States. But again, I would refer you to the America First investment policy, which has quite a bit of restrictions around, particularly focused on Chinese investment, on critical US infrastructure, business, and assets. But it also will, in fact, try to fast track certain types of investments, expedite environmental review of investments of over $1 billion. And again, the IEEPA was invoked to pass this executive order. A couple of things I do want to note as I conclude is that it is unclear whether the tariffs will achieve the goals that were stated, which were primarily for North America to control the fentanyl opioid crisis as well as manage immigration. Canada and Mexico both made efforts to do this at the beginning. Mexico sent National Guards to the border. They have promised as of today they will do more. Canada has also committed to secure the border addressing fentanyl trafficking. But we saw that in 2017, 2018, 2019, there were also 25% tariffs placed on Mexico and Canada right before the negotiation of the USMCA and the conclusion of the USMCA. And the USMCA needs to be renegotiated or reviewed, but might most likely renegotiated in 2026. So we saw that the first term trade war with China hit the US farmers quite badly. $27 billion were lost in export sales. There are proposed tariffs on Canadian softwood lumber, as well as steel and aluminum, which would be using the 232 tariffs. Tariffs can also undercut production in our North American supply chains, particularly automotive, and it can risk isolation and alienating our friends and allies. So what do we do with uncertain times? Well, the best way is to walk right through it. The best way out is always through, as Robert Frost said. And I'm happy to answer any questions, particularly about some of the issues that might be renegotiated in the USMCA, which I think might be very relevant as well in the Q&A. Thank you very much.
Thank you, Professor Trujillo. Our next speaker is Professor Brett Wells, who's Professor of Law and John Mixon Chair at the University of Houston Law Center. His topic is going to be federal income taxation in a time of transition.
All right, well, welcome everyone, and looking forward to a good conversation. But unfortunately, I'm not sure I'm going to make anyone happy. So there's a lot we can discuss, but I think it's important for us to start with the framework that there's a lot of things that we need to make sure we have a clear understanding of, and to understand our fiscal situation. So I know this is a busy slide, but Congress, the Congressional Budget Office, puts together a 10-year forecast of what happens with tax revenue and spending over the 10-year period based on current law. Assuming Congress does nothing in the next 10 years, what is already the expected amount of revenue that is going to be collected under current law and the spending that is already required under current mandates and under current law. If Congress does anything else, then it increases the amount of the commitments. If it raises taxes during the period, then that has an impact. But the 10-year forecast is intended to be a baseline. So I want to speak to that because we need to talk about what we could expect in this time of transition. But to do that, we need to have a level set framework that we can speak from. So in the first part of the slide, you can see that revenues increase from 2025 from 5.1 trillion expected for fiscal year 2025, and will increase by 2035 to be $8.03 trillion worth of government revenue. If you just look at the entirety of the 10-year period, you can see that we expect to generate $67.5 trillion worth of tax revenue during that period. The growth point to point from 2025 to 2035 is that government revenue, just based on current law and forecasting 1.8% GDP growth, would lead the federal government to have approximately a 55% increase in revenue. I like to tell my students that if you go into the tax area and you see that your market base of taxes is going to increase 50% over the 10-year period, what other market segment already has that baked in? So it's a growing source of revenue for the federal government. That's the good news. The bad news is that the government outlays, which are $7 trillion expected for 2025, with a $1.4 trillion deficit, or $1.86 trillion deficit in 2025, will grow to $10.5 trillion in spending in 2035, and we are forecasted to have a $2.5 trillion deficit in that particular year. If we look at the total for the 10-year period, the spending is going to be $89.3 trillion. Remember that number. I want to come back to it in a later slide, but over the 10 years, we're going to spend $89.3 trillion based on current law, and we will add to our debt. We will have cumulative deficits of $21.7 trillion and increase our debt by that amount. For that period, so that the debt that we have in 2025 is $30.1 trillion, and it's expected to grow to $2.05 trillion. Now, given that fairly bleak fiscal situation, on the front of that, Congress is considering a number of tax cuts that they will propose to put in place in order to support the things that were touted in the prior election. First, the so-called Tax Cuts and Jobs Act. Many of the revenue-losing provisions are set to expire by the end of 2025. Congress is considering extending those, making those tax cuts that were temporary provisions that only existed for an 8-year period, not the entire 10-year budget period, would be made a permanent fixture in current law. Also, in that discussion, President Trump has announced a number of initiatives in addition to extending the current expiring provisions, namely no tax on tips, no tax on overtime, exempting Social Security, and the rest. The Congressional Budget Office has scored those proposals. If the Tax Cut and Jobs Acts were extended, it would add $5.2 trillion to the deficit over the 10-year period. And the initial scoring for no tax on tips, removing the state and local cap of $10,000 for deducting property taxes, no tax on overtime, Social Security, you add those up, it would add another $3.8 trillion. So approximately $9.5 trillion of new debt over the 10-year period. Now, the tariffs that have been proposed, if we assume that they are not simply trading bargaining arguments, but we're actually going to collect the tariffs for the entirety of the 10-year period, those have been scored to raise approximately $2.7 trillion in revenue. And the House reconciliation bill that has been adopted as a framework for a future reconciliation bill has modeled that they would expect to have government spending cuts of $2 trillion over the 10-year period, or approximately $200 billion worth of cuts each year. The DOGE website has set that same goal of reducing government spending by $2 trillion over the 10-year period as a goal for the DOGE effort. So if we just sum those points up, the current extension of the existing tax cuts plus the additional tax concessions that were part of the prior election cycle, with an offset for tariffs partially and an offset for spending cuts, those together represent an additional $4.8 trillion in the debt in addition to the $21.7 trillion that we're expecting over the 10-year period. So the point to focus on at this moment is that the added tariffs and the government spending cuts are not sufficient to actually pay for the tax cuts that are being proposed, are being considered in front of Congress today. So the systemic deficit that we looked at in the earlier slide is unchanged, and we are adding to the deficit during the current period. So remember my number that I said before, 89.3 trillion in spending. Well, where is the spending? Where does the money go? And that's an interesting question. And so on this slide, I have reordered the government spending into two different buckets. I've taken all defense spending, discretionary, non-discretionary, the net interest on the debt, Social Security, Medicare, Medicaid, for healthcare for retired or indigent individuals, government retiree benefits, and veteran benefits to those who have served in U.S. military or other government personnel who have who have retired. If I add those together, that represents 77% of government spending over the 10-year period. If I take all non-defense discretionary spending under current law, all income security, poverty offsetting programs, and all other mandatory spending, like paying for the Internal Revenue Service, paying for air traffic controllers, paying Congress's salary, every other mandatory spending program, it accounts for 23% of the federal budget. Now, the reason that's helpful to segment in this way is that we've also heard from the current administration that defense spending needs to be increased. Maybe having a golden dome is what has been talked about, or anti-ballistic protections for the nation. The defense spending has been proposed to be increased, and the current administration has said we will not touch Social Security or Medicare or retiree benefits or veteran benefits. That really spending cuts would come from the all other mandatory programs and non-defense discretionary programs. But if we take the deficits of 21.7 trillion over the 89 trillion, that deficits that are the systemic deficits represent 24% of the spending. Everything else is not enough to cover the systemic deficits. And the extra deficits that we create through the proposed tax reductions that are being discussed in front of Congress today would add another 6%. So the deficits that would need to be dealt with under government spending cuts represent 30%, and that is a far greater amount than the entirety of the portion of the budget where budget cuts are being discussed. So what is being discussed in the popular press is that the government can have spending cuts from less than 1/4 of the government spending, and that those will pay for what are our systemic deficits and the tax cuts that we are proposing for the current reconciliation bill, but the math just doesn't support that number. If we are going to have any real effort to offset the spending, the tax cuts, the loss of revenue, or we are going to deal with the systemic deficits, we must consider cuts in this area, which again we're being told are off the table. So what the situation that is being forecast is that by the end of this next year, we will have a debt to GDP ratio that will equate to the highest debt to GDP ratio that the U.S. has historically ever had, which was during just immediately right after World War II, when we were funding a substantial war effort. And that the debt to GDP would be forecasted to grow to 118% of GDP by 2035, which is an alarmingly large number. So then the question becomes, well, what about raising taxes, not reducing taxes as is being proposed, but actually attempt to deal with the budget deficits in a different mechanism? Tax Policy Center has put together this chart that shows the top marginal U.S. individual rate going back to the very adoption of the 16th Amendment that allowed the U.S. to adopt an income tax starting in 1916. So the 16th Amendment was adopted in 1913, and the first year when the income tax became effective was 1916. So looking at that chart, yes, there was a brief period at the end of World War I, where tax rates were lower than the current rate that we have today. And there was a brief period at the end of the Reagan administration and the beginning of the George H.W. Bush administration where tax rates were below the current rate. But if we look at the US marginal rate today for individuals, the tax rate is at an historically low level. We very seldom have had tax rates as low as we currently have today. Now, I want to go back and make a point that I did not make earlier. If you look at where the federal government collects taxes, approximately 87% of the tax revenue comes from individual income taxes and from payroll taxes. Taxes from corporations, entities, corporations, the corporate tax, other entity type taxes account for less than 5%, or I'm sorry, 9%, less than 9% of the total tax revenue. So when we think about where are the taxes going to come from, if we think that it's going to come from just raising corporate taxes, that's not necessarily an idea that is not worthy of further thought, but it's not going to represent something that moves the needle in terms of the federal budget deficit. In order to move the needle, the tax revenue will have to come from where the tax base is at 87%. And again, tariffs, 2.7 trillion over 10 years or 270 billion per year offsets that somewhat, but it is not going to solve our systemic budget deficits. So the next question that I think is interesting as we think about raising taxes or cutting programs and the rest is to look at the who earns the income in our nation. And this graph has something that both political parties find helpful, at least in part. What is seldom discussed, I think, in the popular press is both sides of this chart. So in this chart, it shows that the top 20% of income earners pay 80% of the nation's taxes, and the top 1% pay 24.7%, so that the income taxes are largely skewed to the top 20%. But there's another way to read this chart, and that is that the top 20% has 55% of the nation's income. The top 1% has 16% of the nation's income. Or we could look at the chart in a slightly different way. The bottom 60% of the nation pays less than 15% of the total taxes, but they have the bottom 60% of the nation, 60% of the country has approximately 25% of the income. What the chart shows is that we have significant income inequality in the nation. And that significant income inequality means that the income, such as it is largely earned by one sliver of the top 20% of the nation. And we have a progressive income tax that is geared toward those that earn the most money. They pay a higher percentage of their income, a higher amount of the taxes versus the rest of the society. But we have two large discrepancies. I will end by saying, when we talk about the deficits, Herb Stein, a famous economist, said that if something cannot go on forever, speaking about the budget deficits, then it will stop. And I think that's a good way of ending this, is that the deficits at some point will stop. But how it stops is an important and hugely relevant question. I'll turn my panel back over to Dean Granado, to our next speaker.
Thank you, Professor Wells. Professor Sunny Wong, who is the Associate Dean of Graduate Studies at the Hobby School of Public Affairs and Professor of the Hobby School of Public Affairs, will now do a discussion on monetary and fiscal policies. Professor Wong.
Thank you, Dean Granado. Hi, everyone. It's my great pleasure to be here to talk more about the monetary policy and fiscal policy. So before I get started about the monetary policy, I would like to introduce about what is the current economic conditions, like in terms of the different kinds of indicators that we usually use for reading about how the economy is doing. So I'm going to present the three of them here, and that would be the GDP growth rate. And currently, the GDP, the economic situation is growing at around 2.5% in the last year. Usually GDP will available for every quarter, so we haven't received the information about the first quarter of 2025 yet, but we do see that we are having a positive growth at the moment, and we hope that will be the continue to be the case. The second information that we also receive is about the inflation rate. The inflation right now, like by the end of January 2025, the inflation rate right now is around 3%. And looking at the based on the consumer price index, and from this year and this the January 2025 compared to January 2024, and we do see the inflation rate is about 3%. And another very important indicator about the economy is the employment rate. The employment rate at the moment, according to January 2025 information, we are at the 4% unemployment rate. You may actually see all these graphs right here, and that's how we do definitely see that about inflation actually went up in the middle of the 2022, 2023, and came down all the way back to around 3%. And I will go and talk more about the inflation and monetary policy more in the later slides. Another thing that is also very important, and whenever we are talking about the monetary policy, would be the labor market condition, the job market conditions. So I'm going to present three graphs right here. We are looking at the change in non-farm payroll employment, looking at the job availability in terms of the available workers and also the available jobs, as looking at what we consider as a labor market, the labor demand and labor supply. We also look at the labor market productivity, and these are the three figures I would like to show you. Speaking about the job market situation, and we do see that the job growth remains strong, especially in the healthcare sector and also local governments. But we do see the declines in other sectors, such as the manufacturing sector in the United States. Speaking about the labor market, and we are focusing on both the labor demand and labor supply. And as you see from the graph in the bottom here, we are looking at the available jobs. That is what can be considered as the labor demand. And in this case, we do see that labor demand is going up, and until last 2 years, it start actually slow down a little bit, and the labor supply is still catching up. So we do see that the labor market is stabilizing as it slows, but the job and workers gap is actually narrow to 0.8 million in the fourth quarter of 2023, and that's the latest that we could get at the moment here. Another thing that we also got here is about the labor productivity, and in the business sector, it actually increased by the 1.97% in 2024. And looking at the last quarter, in the fourth quarter of actually looking at the last quarter, which is 1.97%, and compare with in the past a few years, and the average is about 1.8%. We do see that actually the productivity is actually increasing in this case. Oops, sorry. Another thing that we now want to focus on will be more about the monetary policy. Just to give you some background about how we understand about monetary policy. And the monetary policy refers to the actions taken by the Federal Reserve or Federal Reserve System, which is what we consider as the U.S. Central Bank, to manage the money supply and the interest rates and influence the economic activities. So in this case, you can think about the Federal Reserve System is a central bank in the United States, and it was established in 1913 by the Federal Reserve Act. And within the Federal Reserve System, we have a committee called the Federal Open Market Committee, also what we call FOMC. And FOMC is the committee actually making the monetary policy decisions for the United States. And the major goal of the monetary policy making is to promote the maximum employment, stable prices, and moderate long-term interest rates. And that is the goal. And that's how, whenever they are doing their monetary policy making according to their goal, and this is the three things that they want to make sure to achieve: maximum employment, stable prices, and moderate long-term interest rate. And that's what they are trying to do at the FOMC meeting. So speaking about the Federal Reserve System, I think it's also important to understand about how we understand the federal system look like. In terms of Federal Reserve System, there are 12 districts, and that's what we consider the 12 Federal Reserve banks. Like here, you can actually see the 12 districts from district number 1, which is the Federal Reserve Bank at Boston, and all the way to district number 12, which is the Federal Reserve Bank of San Francisco. And there are 12 Federal Reserve banks in the United States, plus what we consider as the Board of Governors, which is the Federal Reserve. So that together, and that would make up to be the entire Federal Reserve System with the private banks together. And here also want to show you some other location that represents the branches. For example, in Texas, the Federal Reserve Bank will be Federal Reserve Bank in Dallas, and that's the major bank. And in Houston, there's also have a branch as well, the Federal Reserve Bank with the branch in Houston. Talking about FOMC, and the FOMC, as I said, is the way to make the monetary policy decision making. And that is made up of 12 members. And certainly the chair of the FOMC, which is the Federal Open Market Committee, would be Jerome Powell, which is the chair of the Federal Reserve System, and with another 11 members. And they are either the Board of Governors at the Federal Reserve System, or the chair or the presidents of the Federal Reserve banks. Usually the way that we do it, they do is that there are 7 Board of Governors in the FOMC committee, and also 5 president of the Federal Reserve banks that make up to be 12 members in the Federal Open Market Committee, FOMC. Okay, so speaking about the monetary policy, and you probably know already that the Federal Reserve actually setting the target at the moment between 4.25% and 4.5% interest rate, also what we call the federal funds rate. So for what's federal funds rate? Federal funds rate is basically the interest rate that banks charge each other for the overnight loan to influence the borrowing costs in the United States. So in this case, according to the last meeting, which is the January 29th, 2025, and they consider that to hold the policy interest rate steady, and then signal that, but the thing is they signal to actually go to reduce the interest rate in the next few meetings, and that's what they are planning, or they're planning to do. And the reason why they are thinking about this way at the moment is that the Fed cite the strong economic conditions and still have considerations about the future inflation pressure. And that was the reason why they are not exactly sure they're going to lower the rate, but the thing is they are having some kind of planning of like lower the rates in the future FOMC meetings. Probably probably would be like 2 meetings, and like for like a 50 basis point, which is what I'm going to talk more about it as well. Okay, so here is just to give you some idea about like what happened to the federal funds rate, which is the major interest rate that the Federal Reserve control and do the monetary policy. And we can actually see that since the 2020 until 2022, and the first and second quarter, and the interest rate was at the very low level, and until like the mid 2022, and then the federal fund rate start increasing and reaching until like the 5.25 level for a while, until now we are start going down, and in this case. And right now, according to what we call the effective federal funds rate, which is the actual rate that the banks are charging each other at the moment, is around 4.33%. So you can actually see that we do see like a sort of like a cycle about how we see the movement of the federal funds rate in the United States, especially since 2022. Here, it's just like give you a small idea about what happened to the money supply or the monetary policy situations. And I would like to tell you a little more about the balance sheet of the Federal Reserve. And one thing that I would like to tell you is more about what we consider as the monetary base. So monetary base is how much money the Fed actually print and right now in the circulation or as a reserve balance. And from here, this is the figure actually showing you the monetary base since 1960 all the way to January 2025. And you can actually see that from 1960 all the way around the 2008, 2009, we have a pretty stable growth of the monetary base, which is the amount of money the print to the society. Until 2008, 2009, and probably you all know about the financial crisis during that time, and that's something Ben Bernanke, the chair of Federal Reserve, and they start doing something what we consider at the monetary easing, and then actually it's nothing more than like printing more money out, and you do see that like since then we start doing more about the monetary policy easing, and keep increasing the interest, the money supply, the amount of monetary base from like you can think about as from less than $1 trillion in around 2008, 2009, and then all the way now at the level of the $5.6 trillion of the monetary base. And just want to give you more information about the Federal Reserve balance sheet. And here you can see that by doing increasing monetary base, one thing they did is actually increasing buying of the bonds and the securities. And we do see that now the Federal Reserve actually holding 22% of the GDP as the securities. In this case, peaked from the 35% at the end of 2021. And that's why you can actually see the monetary base and the balance sheets, they are actually mirror to each other. And another thing I want to mention is about the federal funds rate, that what the Fed is planning to do. And according to what we observed, and the graph is actually showing you about how the economists are doing some kind of forecasting and also like doing some kind of economic analysis about what will be the appropriate federal funds rate should be in the economy. And we can actually see that if we are looking at right now, this is the green line represents the actual federal funds rate currently, and the other, like the broken lines, those are the interest rate based on different economic modelings. And currently, we are actually at the similar level as what other economists predict or suggest based on different kind of policy rules. Compared to like before in 2001, 2002, 2003, and the actual interest rate somehow is actually lower than what the other economic modeling suggests. And here, just to give you some more information about what the appropriate targets coming from the different participants of the FOMC committee's members. And according to what we observe right now, what they believe that the appropriate target federal funds rate would be between 3.88% and 4.12%.
Sonny,
Yes.
Professor Wong, we've already got a question, and because we got only limited time left, so I was wondering if we could just start the Q&A with this. You could answer this question, which is related to your slide. Question we have.
Of course, I can do that too.
Yeah, so, because we have only 7 minutes left, so there are a couple other things I'm seeing here and questioning. So question is, how have changes in bank reserves and currency and circulation influenced the monetary base since COVID in 2020?
Can you say it again? I'm sorry.
How have changes in bank reserves and currency and circulation influenced the monetary base since COVID in 2020?
Well, that's a very good question. I think certainly the question is for the Fed that they only have one thing they could pretty much could do is more about the interest rate, right? So the interest rate is the major policy objective they could do, and the situations right now is that like they are having some kind of dilemma here, whether the inflation will continue to grow or we're actually going to heading to the recessionary period. So, and now the question is like the Fed will have a more concern about like what to deal with the situation about inflation right now. It's kind of hard to tell about like what the Fed would do, because the thing is, I think according to what they showed to is that like according to the recommendations, they are thinking about to lower the interest rate for 50 basis point for the rest of the year. And this is also the concern they have, because thinking about lowering the interest rate, that means they have to print more money or actually keeping the money supply high. So that will actually making the inflations could, if we think that actually 3% is too high, and the Fed usually set the interest rate at the 2%. So that means they need to think about whether this is a good idea for lowering interest rate in the near future. I'm not sure I actually answered that question in this case.
I think so. I want to turn it to trade for a second too. Professor Trujillo, in our limited time, we're renegotiating USMCA, correct? Or reviewing in 2026. What are the implications for our ally, well, our trading partners?
Yeah, so I think that, thank you for that question. I think it's a very relevant question to the tariff situation we see happening. So there are several issues that I think may be of concern for the United States as they move forward with reviewing or renegotiating USMCA in 2026. And remember, the first USMCA was concluded in 2019 under the first Trump administration. But I think that perhaps some of the issues that have evolved are much broader, right, for the United States now around the America First policy. Clearly, border security, immigration, illicit drug trafficking, these issues are going to be key to get more commitments from Canada and Mexico around this. But also there's going to be other issues like digital services, taxes and fees, minerals such as copper. One of the executive orders also places tariffs on the imports of copper. And so what is that going to look like? But I think rare earths is going to be relevant as well as semiconductors. And the other issue, frankly, is China. Because with the USMCA, with its current rule of origins, as well as the Biden Inflation Reduction Act, which created many tax incentives for EV vehicles and other related items around electrification and decarbonization, the Chinese have benefited from this to some extent by moving manufacturing to Mexico. And they've also been able to roll up some of their costs in calculations in calculating regional content value and benefit from these tax credits under the Biden Inflation Reduction Act. And so I think there is some concern about what the USMCA will do there with respect to advantaging China in this way. I mean, it's not very different from when the first NAFTA was put into place, when at that time it had to do with Japan, and they were using Mexico as an export platform because of drawbacks and other things that were in the that were happening, that was allowing the Japanese to have a leg up on their automotive and sending their automotive cars to the United States easily. This is very similar in terms of, oh, okay, maybe this is something in the USMCA that needs to be looked at least from the perspective of the United States. But I do think that Mexico and Canada are going to have a lot of concerns around these tariffs and whether or not this administration will even want to enter into this free trade agreement or continue it moving forward.
Final question for Professor Wells. It's from our audience. Is your conclusion that the Trump economic policies cannot achieve the stated goals of budget cuts? And can you comment why budget cuts are even necessary?
Well, I think the deficit now that represents 24% of spending is done by deficit spending of the current congressional or the current revenues that are spent. That is so large that I think the tough love conversation we need to have with the public is you can't shift this problem to only one instrument to solve the budget deficit. I think that there's going to be an unhappy conversation about potentially cutting government spending, but that's not near enough. It's the ability to cut government spending in a way that meaningfully impacts the systemic deficit. The numbers don't support that. I think we also need to think about having significant more revenue to fund the government that we believe is needed. So I think that unfortunately, both parties are giving half the story to their political base. It's why I'm, Dean Granado, I don't think I'll ever be a politician because there's not a happy answer to anyone. The problem is so large, it's going to require someone to feel an unhappiness about the resulting compromise.
I want to thank our panelists, Professor Brett Wells, Professor Elizabeth Trujillo, Professor Sunny Wong for this conversation. And there are some other questions remaining from the public that are viewing this. I believe we will be able to answer those in due course offline, but thank you all. And Professor Baines, Dean Baines, floor is yours.
Someone stopped my video. I'm having some technical difficulties. Christina, are you there? It says I can't. Oh, there we go.
There you are.
Good. How are you? Thank you, Dean Granado, and that really great panel on economics and trade and taxes. So now we're going to talk to higher education, which has been in the news a lot. We have three really terrific panelists, and I will mention them in beginning, and I'll turn the floor over to them. So first is Dr. and I'm going to be a very brief introduction because they can read their bios online. So Dr. Kathy Horn, she's the Dean of the College of Education at UH, and she's the Elizabeth D. Rockwell Chair and Professor. So let's welcome Kathy Horn. Seth Chandler is the Law Foundation Professor of Law. Let's welcome my colleague, Professor Chandler. And Dr. Geronimo Cortina is the Associate Professor and Director of the Faculty Research Initiatives at Population Health at the University of Houston. And he often is on Party Politics on our local NPR station with Professor Roddenhouse. Let's welcome Dr. Cortina. So I now turn the floor to Dr. Horn, my colleague and dean, to talk about higher education sort of generally. Welcome, Dr. Horn.
Thank you so much for having me. And with confirmation that my slides are showing, I will get started. I really appreciate the invitation, Dean Baines and Dean Granado, to be part of this event. It's always a pleasure to be in discussion about important topics broadly and certainly personally very near to the heart around higher education in particular. So today I'm really going to focus in on one aspect of some of the changes that have happened in the initial part, the very early part of the current administration's tenure. You heard Dr. Baines talk about this in his own introduction to this entire afternoon. And so I'm going to be focused in specifically on the supplemental guidance to the 2024 NIH grants. And I realize that for some of you, this may be a little bit like, wow, I'm not sure that this is the topic for me, or may feel a little bit esoteric, but I hope in presenting context and implications for this this potential change, that I am able to persuade you that understanding this particular set of guidance is important in its own right, and has some things with respect to implications for broader considerations in the higher education space moving forward. So I will spend my time with you first with a brief primer on what this notion of indirect costs is and is not. We'll talk a bit about the supplemental guidance and what was issued in that February memo, and then focus in on the considerations, including potential impacts of this shift if it in fact goes forward as described. We'll end with just a brief introduction to what the current status of this memo is. I disclaim at the beginning, I am not an attorney. I like to hang out with them and do lots of work with them, but I will not be the legal expert in this space, but will reference, I will try to play one well on TV, if you will, just to orient to where we are in the litigation status. So I want to start with just a bit about what this notion of indirect costs or IDC is, and why does it matter? So to be able to understand what indirect costs are, it's important to first orient around these ideas of direct costs. So when researchers at institutions or other organizations that are funded through federal agencies seek competitive funding, which is the case in any circumstance like a request for proposals, they are required to lay out a detailed plan of action. In the case of NIH funding, a research plan. In developing the associated budget to support that proposed plan, direct costs are those that are specifically identified with that research project and can be directly assigned to research activities described. So in some ways, really thinking about direct costs, you can think about them as representations of resources needed, financial resources needed to execute this particular project. This is a process that goes through rigorous peer review, and again, is really aligned to the quality and expectations of what is being proposed to be undertaken from a research standpoint. In comparison, an indirect cost is really one that's not associated specifically or only with a single project, this project that I referenced, but are expenses that are ultimately beneficial across multiple research projects. Sometimes you will hear indirect costs referred to as facilities and administrative costs, and these are akin in some ways procedurally to what industry or corporate billing might refer to as overhead costs, but with much tighter boundaries, and I'll say more about that in a minute. So the reason that you can think about indirect costs as administrative or facilities in nature is those are the boundary conditions that exist with respect to the approaches or utilization that these funds can be applied to. So in the administrative category, indirect costs that come as a function of an approved federal grant, and again, in this case, we're talking specifically and only at the moment about NIH, is these ideas of general administration, so services that might come through payroll, purchasing, financial management. These often are costs associated with personnel who are needed in support of these kinds of processing requirements that are a function of the successful execution of any grant. Administrative costs might also involve broader, more generalized research-related costs at the department or the college or the full university scale. And then there's also indirect costs that can present in the form of units that might establish research or training, regardless of source. So this might be units that address compliance or research requirements, again, not directly tied to a single project, but essential to the capacity to execute across multiple research projects. And then finally, under administrative costs that are generally approvable with respect to utilization of IDC or administrative funds is graduate student services, specifically supports that are in alignment with students affiliated with research projects. This other area of appropriate expenditure with indirect cost resources is under this big umbrella heading of facilities, research, and infrastructure costs. So these are the kinds of things that term might call up for you: building depreciation, interest or debt for certain buildings, equipment, or capital improvements, equipment depreciation on equipment that wasn't purchased directly with federal funds, and then the general notions of operations and maintenance, utilities, maintenance, custodial, environmental, health, transportation, security. So a fairly large bucket of supports that can be appropriately paid for in part through indirect costs as a function of a received federal grant. The important piece about indirect costs, so the idea that indirect costs sit separate and in distinction from direct costs is accurate in the sense that their pathways towards utilization are different. The important piece, though, to understand is that the totality, that direct plus indirect cost, is all ultimately awarded in support of research. So universities, back to this idea of the analog of overhead, universities don't have unfettered flexibility on the ways in which they can spend received indirect cost funds. They are required by purpose to ensure that those resources are connected to research, different, for example, from instructional or other activities that are also part of a university's ecosystem. So the memo issued in early September laid out the expectation. Let me move me. The memo indicated that the United States should have the best medical research in the world. It is accordingly vital to ensure that as many funds as possible go towards direct scientific research costs rather than administrative overhead. NIH is accordingly imposing a standard indirect cost on all grants of 15%. As this excerpt from a longer memo summarizes, the indicated intent of this updated guidance was that this move towards a flat rate much lower than essentially all institutions are currently receiving IDC rate moves the total funding approach towards something that more closely the language in the memo describes as comports with market rates. I will not go into a full history of how the evolution of how federal indirect cost rates have been established and changed over time. That probably is really esoteric for this discussion. But let me offer a very short summary. We have moved historically over roughly the last 75 or 80 years from early approaches that really were analog to what you're seeing in this current memo, with a set fixed upper limit that was much lower, between 15 and 25 or 30%. to a process in Current where there is institution by institution negotiation in the total amount that can be represented in indirect cost that is captured in what's called an indirect cost rate. So that is often for institutions, and especially for research intensive institutions, a rate that is somewhere between 50 to, in some cases, although this is on the high end, as much as 65 or 70% of the total grant. So to think about that practically, if a total grant award is for $1 million, a proposal would account for up to, and an IDC rate was at 50% to do easy math. The award amount would account for $500,000 that would go directly to the research project being proposed, and $500,000, or the other half of the $1 million, to go to these indirect costs that are in part associated with this particular project and in part associated with the broader expectation of and needs of the research enterprise. So before I lay out the arguments both proponents and detractors are surfacing for this new guidance, I do want to offer a glimpse into objectively anticipated impacts of this shift if it goes through. So this is a map that just represents the dollar amount that is expected to be lost if the IDC rate for NIH drops to 15% flat rate. So one point to note is simply that there is no state unaffected by this decision. There's representation across the country of direct loss of funds that will have some kind of impact. But what you also notice here is that varies. So if you look at a state like Wyoming, they are estimated to lose about $1.8 million if this goes into permanent effect. While states like California, New York, Texas are perhaps unsurprisingly anticipated to lose vastly more dollars. So California is anticipated to lose upwards of $800 million, New York, $623 million, Texas, $310 million. So this has the potential to substantially negatively impact states' general capacity to execute research and in other spaces as well. To that point, there's been quite a bit of effort to understand in real time what those other impacts might be beyond only a muting or truncating of capacity to execute the science that's being proposed and is historically funded through NIH. And I'll surface one that's been in the news quite a bit, and that's Alabama. So Alabama is slated to lose just about $47 million if the IDC rate drops to 15%. What you may not know, for those who don't know Alabama well, is that the University of Alabama at Birmingham is a top 30 recipient in the country for NIH funding. There's amazing work happening at this institution. So an IDC rate cut would have would likely have direct and substantial impact on the institution itself. More broadly, though, the research enterprise at the institution is also a very well-documented lifeblood to Birmingham's economy. So there is most likely also to be a regional effect as a function of this decision, which would be true in many places across the country. So proponents of this guidance have several arguments in favor. First, and probably most logically, is the notion of cost effectiveness. The idea being that by capping indirect costs, the NIH really can, from their vantage point, ensure a greater proportion of the grant funds are being used directly on research activities rather than on administrative or overhead costs. There's also, and this second point is in fact referenced in the guidance itself, the move to something more akin to 15 or 20% argument goes, aligns more closely with private philanthropy. So they reference large foundations like Bill and Melinda Gates, foundation that I guess it's now just the Gates Foundation that is really keeping indirect cost rates low. Again, in argument that the bulk of the dollars ideally go to the research itself. There's the idea that this is a market-based strategy, which is the notion that it really creates a more competitive opportunity for, I'm seeing Dean Baines, which means I should stop talking, a more competitive opportunity. Really quickly, there's also arguments against, which include disincentivizing research institutions and unintended consequences. As the American Association of Medical Colleges says, with this cut, everyone has benefited from from research produced by the NIH, and everyone is slated to be harmed. There are 3 lawsuits in play, and the bottom line is we're in a wait and see format. So thanks, sorry for going over, and excited to talk more. Thank
you, Dean Horn. That was very educational. I learned a lot. So let's now turn it over to my colleague, Professor Chandler, who's going to talk about gender ideology and gender and sex and Title IX. Thank you, Professor Chandler.
Hi, well, thank you very much. I'm going to be talking about gender policy in higher education. Here is an important caveat. You may see a lot of dinosaurs on my slides, and this is the modern version of footnotes. So if you take a photo of this, you will actually get a link to the source that I'm depending on. So this is complicated, and I think the only way I can figure out to organize it is chronologically. So we're going to go back in time a little bit. There's this thing called the Constitution, and it treats gender discrimination by government as being protected by the Equal Protection Clause, or being barred by the Equal Protection Clause of the 14th Amendment or the 5th Amendment. We've got intermediate scrutiny, you may remember from some distant law school class, which says that government has to show an important governmental interest, and that what it's doing has to be substantially related to that interest in order for there to be differential treatment by sex. How does Congress police against gender discrimination? It can either do so either through Section 5 of the 14th Amendment, or through the Commerce Clause, or through the Spending Clause, through conditional spending. So we do see a number of statutes that have been enacted pursuant to the Commerce Clause, the Spending Clause, and Section 5 of the 14th Amendment. Let me start with Title VII of the Civil Rights Act of 1964, which says that it's an unlawful employment practice for an employer to do bad things because of such individuals' race, color, religion, sex, or national origin. But the statute does not explicitly mention sexual orientation or gender identity. All right. We've got another statute in play, Title IX of the Education Amendments of 1972. This one has a somewhat similar provision. No person in the United States shall, on the basis of sex, be excluded from participation in or denied the benefits of any program that's receiving federal financial assistance, which includes virtually all of higher education. It doesn't define what we mean by sex. Again, it doesn't say sexual orientation. It doesn't say gender identity. And unlike the Title VII provision, there are a number of exceptions in here, for example, for fraternities or beauty pageants or military or merchant marine training, etc. So in modern era, we've had to come to terms with to what extent do these statutes protect against discrimination based on sexual orientation or gender identity. And the leading Supreme Court case here is Bostock versus Clayton County, in which the issue was whether when an employer discriminates on the basis of homosexuality or being transgender, is that because of sex? And the Supreme Court says, yes, that is because of sex. If you think about it, it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. And the court didn't find persuasive the notion that this form of discrimination wasn't what was on the minds of the people back in 1964. When they enacted the statute, the court said, look at the words of the statute. They do, however, add a caveat here, which is we don't purport to address bathrooms, locker rooms, or anything else of the kind. All right. So what about the Equal Protection Clause? Has the Equal Protection Clause been Bostocked such that discrimination on the basis of sexual orientation or on the basis of gender identity is going to be treated the same? And the answer is not quite. There's no formal ruling exactly saying it's the same thing. On the other hand, the court hasn't rejected the idea of, for example, gender identity being treated as a form of gender discrimination. There is a case pending before the Supreme Court, United States versus Skermeti, which may end up addressing the extent to which the Equal Protection Clause protects against discrimination based on gender identity. And we have a split in the circuit courts on the matter. So we will see. All right, that brings us to the regulation of the Biden administration, which following the Bostock decision says that discrimination on the basis of sex, and this is a Title IX regulation, I should say, discrimination on the basis of sex, that is, it's trying to Bostock Title IX. Discrimination on the basis of sex includes discrimination on the basis of sex stereotypes, blah, 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 sexual orientation, and gender identity. Okay, so this provokes a counter-reaction. Largely red states, conservative organizations, some individual plaintiffs say that this is extending Title IX beyond what was intended, and they're buttressed by 240,000 comments on the Biden regulations. It gives rise to two lawsuits, Tennessee versus Cardona and Kansas versus United States, both of which hold, they're very similar in their holdings, and they try to distinguish and say that because of sex in Title VII, Bostock, is quite different than on the basis of sex, which is the language in Title IX. Moreover, because Title IX is based on the spending clause, based on cases like South Dakota versus Dole, you can't just sort of change the regulations in the middle of the game. That there needed to be more of a when people accepted the money, they didn't know that this was coming. Moreover, the fact that there are exceptions to the Title IX prohibition suggests that gender identity doesn't count, and they also had some problems with other provisions of the Biden regulations, like being required to use preferred pronouns violates the First Amendment, and besides, they thought it was vague. All right, so, and you'll see the dates on this, right? This is one day before the inauguration of President Trump. So now we have a change. We have President Trump and Vice President Vance sworn in. And on his very first day, what does President Trump do? He basically decides that he doesn't want any part of what the Biden regulations did. The erasure of sex in language and policy has a corrosive impact, not just on women, but on the validity of the entire American system. Basing federal policy on truth is critical to scientific inquiry, public safety, morale, trust, and that we shouldn't be replacing the immutable biological reality of sex with an internal, fluid, and subjective sense of self unmoored from biological facts. All right, so what does he say? First of all, he says there are two sexes, and sex is an immutable biological classification. It does not address, by the way, the existence of intersex people, which is a little bit of a scientific bug in the theory that there are only two sexes. But in any event, we get three key policies that emerge from this, I would say. The first is that agencies are not supposed to talk about things about gender ideology, and this affects organizations like NIH, which Dean Horn spoke about, NSF, which I'll mention in a moment, the Department of Education, to the extent that that still exists. We have federal funds that are being prohibited from being used to promote gender ideology, and because so much of higher education is funded directly or indirectly by the federal government, that is a big deal depending on how broadly gender ideology is interpreted. And finally, the Attorney General is supposed to basically promulgate the notion that Bostock, whatever we make of Bostock, it shouldn't be extended, and essentially cases like the Cardona case and the Kansas case were correct. All right. So that was the general idea. That's what he got out. He got out on the first day in office. But 2 weeks in, we have something else, which is an order that prohibits transgender women and girls from participating at female sports teams in educational institutions. And if you do so, if you permit that, looking at you, Maine, we will cut off your federal funding because it violates, in our view, Title IX, permitting non-women to or what they see as non-women to participate in women's sport constitutes a form of discrimination. And in their justifications, they cite the Cardona case, they cite the Kansas case, and here's their justification. That's where we are. Is this a minor matter that the Secretary of Education is supposed to handle? No, it is a priority for the Secretary of Education, and we're supposed to review all grants to educational programs and make sure that everything is in conformity with the new theory of Title IX. That's where we might have stood if this CLE had been held like a week or two ago, but there's more. So there is a claim by I would say supporters of President Trump. I haven't heard the president make it himself, but that the Biden administration politicized scientific research and that they increased the fraction of NSF grants going to what they term DEI from 0.29% in 2021 all the way to 27% in 2024, which they clearly believe is way too much. Therefore, as a way of counteracting that, and this, I will say, is not totally confirmed. Like, this is what the Washington Post reports. It's what NPR reports. But I have not seen, and I've looked for sort of the primary document confirming this. But allegedly, there is now a list of words which will trigger heightened review in your grant application. Those words include things like disability, discrimination, equality, equity, female, that's going to get you nailed, gender, historically, that's a bad one, and all of these words that are listed here, including women, although not men. It doesn't mean that your application is denied, but it sort of means that it's set aside. And one wonders, given budget cuts and turmoil, whether being set aside means delayed for an awfully long time. My little footnote is if Elon Musk is such a big believer in large language models, this is a very crude proxy for DEI, and maybe they should have used something more sophisticated. And just for example, like this grant application will be flagged because it uses equality, inequality, and diversity. This grant application is going to be flagged because even though it is a conservative approach to the matter, it nonetheless uses the same words that more progressive people might employ. All right, finally, there's this whole issue of, do we even have a Department of Education? And as of this morning, I was going to tell you, based on what I was reading in the news, that we weren't going to have a Department of Education, or at least there was going to be an effort to close it down. But as of this afternoon, the president's press secretary has described that as fake news. And so as of March 6th at 3:41 p.m. Central Time, to the best of my knowledge, the Department of Education lives. Can the president even abolish the Department of Education? And I think the answer is no, not on his own. There used to be laws in place that permitted the president to juggle with cabinet level positions, but that expired in 1984. And so I believe to actually abolish the Department of Education, it's going to take legislation through Congress, which maybe he will get, but sort of the regular process. Now, can he defund the Department of Education? That's a complicated story about impoundment. So let me just talk about, though, what does it mean if the president's new ideas about rescinding the Biden regulation, in fact, go into effect? And so there are a number of things that some schools might now want to attempt. I don't think actually many will for a variety of reasons, but it's not beyond the realm of possibility at some recipients of federal funds. So, for example, we might want some schools that had codes of conduct that were more traditional, that barred people dressing in a way that wasn't in conformity with the traditions of people of their birth gender. We might deny transgender students access to dormitories or bathrooms that they would prefer to go in. You could possibly refuse to admit openly LGBTQ students. You could possibly deny LGBTQ students funding, and you could perhaps eliminate LGBTQ topics from curricula. I'm going to come back to that in 1 second. Maybe restrict counseling services. However, in saying all of that, the fact that the Title IX regulations no longer prohibit that doesn't mean that it's legal, nor does it mean it's going to happen. Because if the schools weren't doing it before the Biden regulation, it's not so clear that they would do it now. Moreover, the president can't get rid of Equal Protection Clause challenges by executive order. President can't get rid of Title VII employment discrimination or Bostock by executive order. President can't get rid of the First Amendment by executive order. And by the way, I've flagged for you here, I think the lead Supreme Court case on government employees, and then a Ninth Circuit case limiting the scope of Garcetti. And I picked the Ninth Circuit because I think it's the most articulate. There are a couple of others, but it is by no means the last word. Moreover, let's not forget about state law. That is, there are state constitutions and state laws that provide protection for transgender and same-sex persons, and those will not necessarily go away as a result of an executive order. So with respect to policy considerations, since I'm going to offer a few opinions here, one is, I think that people who have a more liberal approach towards sexual orientation discrimination or transgender discrimination need to get this thing away from Leah Thomas. Leah Thomas is a very, provocative issue, but of the 92,000 Division I female athletes in the United States, maybe there are 10 to 20 that are trans or intersex. And so trying, in my view, to win the hardest possible battle, which is sort of this full-out victory that trans people can participate in absolutely everything, I wonder if they haven't alienated an awful lot of people, because if you look at the data, 79% of the public opposes trans participation in women's sports, and that majority transcends party affiliation, moderates, and, you know, they may not like President Trump for other things, but at least they kept the trans person out of my daughter's wrestling match. So instead, I wonder if there shouldn't be a focus on things that I think are actually more important, including healthcare for trans people, counseling due to the extremely high suicide rate, which is, you know, partly due to discrimination, passport issues. Does it really hurt anybody if a trans person changes what's on their passport? People might want to go after the NSF flagged word policy for the reasons that I highlighted. And then if we're really talking about science and truth, what do we do about this inconvenient fact that, in fact, sex is actually not that simple, that we have things like androgen insensitivity syndrome, we have people who are XXY, and so this notion that there are just two sexes, in my humble opinion, and I know this will get me in trouble with some people, but I hope still have free speech, it just isn't quite right. And once you get that foot in the door and recognize that it's a little more complicated than that, then maybe some of the simplifying assumptions that underlie the argument start to disappear. The final policy consideration, I would say, goes a little bit back to Dean Horn's comment, which is that the academy, I think, has become extremely dependent. Some might dare say addicted to federal money, and that's been very convenient so long as the ideology of the granting entities has sort of roughly aligned with the ideology of the recipients of the grants. But if you're going to lose elections and your research grants now begin to be politicized, or were politicized perhaps even before, then we need to think very hard as a body about diversifying funding sources. And I think the only other thing I will say is that before people get too concerned, there is no legislation pending that I could find that is attempting to overturn the Bostock decision, nor has the Attorney General yet issued her guidance on what Bostock means. And so with that, I guess I will stop. It is I have other slides, but I will spare you on other parts of gender policy. So thank you.
Thank you, Professor Chandler, for very educational discussion of these complicated issues. Now I'd like to introduce Professor Geronimo Cortina, who's Associate Professor and Head of Health Policy Research at the University of Houston.
Thank you, Dean Baines, and thank you very much for the invitation. I'm going to try to do this in less than 9 minutes so we can get on schedule. So I'm going to be talking about the DEI related executive orders. But before we begin, I just want to give a little bit of context in terms of what are the policy implications of certain mingling with DEI initiatives, policies without any substantial, I would say, any judgment in terms if they're right or wrong or whatnot, just from a pure policy perspective. So these slides shows the schools that are in Harris County and the surrounding Houston metro area. And basically each color represents the percentage of a particular demographic group that have a majority in a particular school in these geographic areas. So here we have, for example, the schools that have a majority of white students, the schools that have a majority of African-American students, the schools that have a majority of Hispanic students, and the schools that have a majority of Asian American students. And then here on your, I guess, right-hand side, you have the academic achievement score by school and by districts, and it's just the grade standardized scale. So it's just the geographic representation of those schools that are below the standardized scale, and those are going to be above in green dots. So what you can see here is that there tends to be a spatial clustering between those schools that are below the standardized scores, with the presence of a minority group being highly represented in those schools. So that's what I'm going to say, and I'm just going to ask you to keep these in mind when we're going to these things, so at the end we can understand what are some of the potential policy implications. So executive orders are just a direct presidential directive to the bureaucracy, right? And they are saying to the bureaucracy, you have to do X, Y, or Z, while bypassing Congress or any other legislative process. There are certain things that in order to change the behavior of the bureaucracy have to be taken into account. Sometimes executive orders do not take those things into consideration. For example, rules, regulations, statutes, even the Administrative Procedures Act, et cetera, et cetera. Executive orders are not a law per se, but they have the effect of formal status and legislation. So they are within the legislative powers of the executive, of the president. However, they're not a statute or a law as we know them, because they're not passed by Congress. Congress can contest an executive order, basically passing a law saying doing that executive order is illegal. And obviously we go through the legislative process. The president could veto, then the House and the Senate can override that veto, so on and so forth. Or the judiciary can basically declare them that are unconstitutional. And in many cases during our history, we have seen that those, even if the Supreme Court or a district court has declared them unconstitutional, the president might choose to ignore such declarations by the judiciary. So we have basically 4 DEI-related executive orders since President Trump took office. The first one is ending radical and wasteful government DEI programs and preferencing, initial rescissions of harmful executive orders and actions, ending legal discrimination, restoring merit-based opportunity, and the U.S. Department of Education letter to institutions of higher education, commonly known as the Dear Colleague letter. So all these executive orders, in my mind, have 5 common denominators. So the elimination of DEI mandates and preferences basically directing agencies to end all practices, programs, so on and so forth, that prioritize DEI consideration in federal contracting, in hiring, in admissions, and many other areas. The shift toward merit-based and non-discriminatory practices is a reversal of what the administration considers preferential treatment towards a particular group, and try to focus solely on individual qualifications and performance. The rescission and reversal of prior policies, such as Executive Order 11246, that was signed by President Johnson back in 1965, that established for example, the requirements of non-discriminatory practices in hiring and employment, has been rescinded, and also 78 other executive orders that previous administration did in order to increase equity and opportunities for various groups. Interagency coordination and oversight, that's a very interesting path or an interesting outcome, because the order asks for coordinated actions among multiple federal agencies. You have the Department of Justice, you have the Office of Management and Budget, you have the Office of Personnel Management, and all these agencies are trying to carry out a comprehensive elimination of DEI policies, whatever they mean, in all across the federal government. And finally, the guidance in light of judicial decisions. So all these executive orders have promoted or have issued some guidance in response to judicial rulings. And in particular, those are going to be related to the use of race in decision-making. And one of the cases that I want to focus on is on Students for Fair Admission versus North Carolina and Harvard, because they're very illustrative. So first of all, in Students for Fair Admissions versus Harvard, the Supreme Court ruling basically says that explicit consideration of race as a factor in making individual decisions is completely unconstitutional. This has been the law of the land since 2023. And in this ruling, especially in the majority opinion of Chief Justice Roberts, he highlights that how race affected his or her life, be it through discrimination, inspiration, or otherwise, that's fine. And also, the student must be treated based on his or her experiences as an individual, not on the basis of race. And this is extremely important because the Dear Colleague letter of February 14 indicates that none of these things are going to be legal, and none of these things are going to be permitted by the Department of Education, and therefore higher education institutions risk losing federal funding if they're not abiding by their interpretation of the Supreme Court case. In the frequently asked questions about racial preferences, we also see that differences in terms of what can and cannot go according to the Department of Education's own interpretation. So the first thing is that in any executive order, in any opinion, in any advice, anything cannot go against lawful practices and policies. If the law allows a institution of higher education do X, if an executive order, if an opinion does say the contrary, well, that is a case for the Supreme Court or the judiciary system to determine if the executive order is constitutional or not, given the current statutes that we have. The frequently asked questions and their colleague letter have saying that relying on non-racial information as a proxy for race and making decisions based on that information violates. But that is contrary to Chief Justice Roberts saying that experiences can be used as a proxy, perhaps, or as or not as a proxy. And we have other lower court cases that affirm or upheld, for example, race-neutral but conscious practices, and also the fact that higher institutions of higher education can enhance diversity, which may not necessarily be the same and intend to disadvantage a specific group. So given these things, the cases that we have, all the case law that we have in terms of these particular cases are saying basically, yes, you can improve diversity, but only if you do not have the intent to discriminate. And then here we enter into the wonderful world of the Arlington Heights versus Metropolitan Housing Development Corporation. And as you would know, these Arlington Heights test is used in many other cases, for example, in redistricting case law, in redistricting cases, but it's very, very, very hard to implement and to demonstrate that there has been a consistent pattern of actions intended to discriminate a particular group. So what this is telling us in this regard is that experiences of individuals matter, that universities may not simply establish through application essays issues related to race, but they can take into account the experiences. And also in the Supreme Court ruling, it says that universities can do whatever they want with their missions as they see fit, as long as they fall within the realm of that. But the real question here, the real problems here is, what do we understand and what are going to be the policy implications? So as you know, Title VI and the Equal Protection prohibits discrimination based on race, based on color, and national origin. And the executive branch doesn't have the constitutional authority to define what is and what is not discrimination under the Constitution and especially under existing law. So that is something that Congress should ask and should act in terms of what is it and what is not Constitution. But from a policy perspective, I think here we enter into a very complicated dilemma of causality. And this is correlation versus causation, and this is the relationship that exists between merit, that exists between race, that exists between socioeconomic status. The demographic composition of the country, the demographic composition of our city, of our state, right, is turning into a multicultural, multi-identity population, right? And the goal of having higher education is to develop human capital, so we can still be applying to NIH, so we can still be the leaders in medical research, so on and so forth. The question also highlights, what are we going to do with backgrounds, with perspectives, and with different outcomes and with different outputs from public policies? What is the intention that we're trying to basically achieve while providing a public good such as education? And finally, a big question that we're going to see in the next couple of days is going to be, how are we going to balance Supreme Court rulings and executive orders with current statutes? So this is going to be a very interesting time in terms of how the Supreme Court is going to think about these things, given all the hundreds of years, well, not the hundreds of years, but the years and decades of jurisprudence that we have in discrimination matters. So let me leave it at that, and I just went over 1 minute. So back to you, Dean Baines.
Thank you, Professor Cortina. Really great. Three panelists, absolutely excellent. So let me ask you a few questions. We have 10 more minutes. So Professor Morales, you may want to wait a second. Thank you. The Wall Street Journal had described what's going on as a shakeup in higher education. So first is this a shakeup? And it's certainly a quick shakeup since a lot has happened in the last 6 weeks. So would you describe it as a shakeup? And what do you think it's caused by? So two-part question. What do you think it's caused by? And what do we do to figure out what happens after the shaking up is done? The question, right?
Well, I think that, it is a shakeup, right? And policy change, at least from everything that we know from the literature, moves at very glacial paces. Institutions are going to resist. But again, I think that the big question here, what is going to be the policy goal, right? As our country becomes more diverse, as total fertility rates among non-Hispanic whites keep dwindling down, what is the end goal that we're trying to achieve? Are we trying to achieve a highly educated younger population? Are we trying to achieve something else? So I think that the discussion of the goals have to be very important, and those discussions have to be taken by Congress. Unfortunately, this Congress doesn't seem to be quite productive as we have had before. And obviously the issue of political polarization is something that impedes the passing of public policy that is going to attend the needs, the wants, and the preferences of the public.
Any other thoughts, Professor Chandler or Dean Horn?
I guess I would agree that I don't think there's any question but that it's a shakeup. I think President Trump, if he were on the CLE, would say, you're darn right, it's a shakeup. That's just what they need, or something similar to that. If you look at the anti-DEI positions of the Trump administration, their letter to colleagues that they sent out recently, which bar things like use of proxies for race, that is very contrary to what has gone on at many institutions. It's viewed quite hostily, perhaps rightly, by many institutions, and it's going to cause immense conflict. And so between that and cutting off a huge amount of federal funds on which many schools really depend for their operations, they figured out how to hurt academia. And I think actually, if that's their goal, they're doing a pretty good job. And if also you couple that with what state initiatives are doing, it's a double whammy.
Dean Horn.
I would amplify, in agreement with both of my colleagues, I would amplify Professor Cortina's wondering about toward what end, right? And really being mindful in the policy debate about those larger impacts, both immediate and long-term, that are, I would argue from an empirical base, central to really understanding how to cultivate and execute well-formed policy. That to me is a really central question that I think continuing to reinforce is worthwhile.
Could I just say one more thing?
Yeah, sure. Good.
I think it's pretty clear what the point is. If you look at the academy, it's about 90% Democrat. The money that flows in goes 90% to Democratic candidates at least. And if your main goal is loyalty to an agenda, then what you want to do is to defund the people who don't agree with you. And I think that's what he's basically doing.
But I guess what I would follow up is that what is the end result? Apart from politics, yes, maybe that shapes or transforms the ideology of higher education. Let's assume that is one of the goals that you're suggesting as a goal. If that does happen, okay. But then the question is like, what happens, in where we are if you do defund research and you do, make it more of a challenging environment for, as you said, LGBTQ people, students, others, faculty, for people of color. It may make it much more difficult to get in, but it makes it more difficult. And as Professor Cortina says, well, the environment, the population base is changing. So what do you end up with, I guess, is the question, is sort of what I think Professor Cortina is saying. So Like the end result might be you might have more ideological diversity, which is fine and worthwhile goal, obviously. But will you have the workforce that you need to do what you need to do? I guess is the question, right? That would be the question.
So,
That's educated and whatever that is, that will move the state or the nation forward.
the answer to that is simply to your second question is no, because whether you want to put a different etiquette or a different label to something that happens, the data and the reality suggests that there are very important differences, right? Very, very important differences, as I show in the slide, in the sense that people are underperforming, and those people that are underperforming tend to be from a certain particular demographic group, which tend to be also the growing majority. So if you want to keep growing human capital, you have to do that. And here I think the deeper question is not about the quantity of opportunities. Every single kid has the right to go to school, to go to a private school. There is no question on that. The question is the quality that the education is receiving. And finally, and probably going with Professor Chandler, higher institutions need to also evolve in this current climate, right? And if we are going to embrace the free market of ideas, we have to embrace the free market of ideas, and we have to debate ourselves and between ourselves that free market of ideas and let the best idea win. As simple as that. That's why we're scientists.
Dean Horn, you have any thoughts? And Mike, could you couple this also? There was an item to cut back on funding, sort of generally potentially Pell Grants and all that. I mean, so if all that happens, I guess is what do we have? What do we have with higher education? I guess the question.
Yeah, two comments. One, to your the part of your question that was really around sort of the opportunity to advance science. I think we can anticipate a slowing at best of our sort of leading capacity to be enhancing the knowledge base that ultimately translates to those kinds of medical supports, the interventions that we know matter in terms of saving lives and advancing quality of life, as just two examples. So that piece we should anticipate at best slowing as a function. But I do want to come back, and I think the other aspects of cutting will have direct impacts, some more than others on the immediate experiences of students, right? The financial aid piece that you surface will certainly have a chilling effect on opportunities for students who are coming from a low-income context to access highest quality public and private education at the post-secondary level. I guess I want to. This is going to be my theme for today, which is to amplify Geronimo. I do, and Seth in this case, right? I do think that there is space for higher. There was a question in the chat. I do think there is space for higher education to be increasingly effective as it is challenged to be increasingly efficient at the work that we do, right? That's part of our opportunity, and it's one that we rise to, right? I mean, we are thinkers by nature, right? So I think that's important, but it has to be in the context of the balance of what large what macro cuts without sort of micro contextual attention means with respect to unintended consequences as much as the intended ones.
I'll do one more question. I know I'm running out of time, but it's from the chat. And I think it's very important. It's like, well, what about merit-based? Wouldn't that make a more efficient and successful workforce? And then you can answer the other question in the chat. Any thoughts?
On merit-based?
Yeah, merit-based, yeah.
Sure, but like absolutely 100%. But the question is, if you go to school, to River Oaks Elementary, I don't know if it exists or not, and if you go to Galeana elementary school. There's a difference. You both went to elementary school, then your middle school is going to be determined by elementary school, high school, et cetera, et cetera. So there is the question, right? And that's the data, what is telling us. So that's something that we need to grapple with without, from a pure public policy perspective. The problem is that all these things have become extremely politicized. So therefore, it's extremely difficult to have a conversation that just look at the numbers and say, how do we fix this? Just fix it. That's a problem that I see from a public policy perspective.
Seth, go ahead, please.
Yeah, I was going to say there's a couple of comments in the Q&A which are sort of related to this, which is, wouldn't primary and secondary schools be the place where improvement needs to occur? And I would say absolutely, absolutely. That is, affirmative action is essentially a Band-Aid to deal with problems that occur in inequality much later on. And it's one of the reasons why, things like SAT scores are imperfect predictors, because they don't take into account the suppression of abilities that's taken place earlier as a result of not very good education. And so I think it's a little more complicated. Again, I tend to think things are complicated. It's a little more complicated than saying, we should just pick people with the highest SAT scores. Moreover, I would say that there are some, perhaps not as much as some people believe, but there are some virtues in some contexts to diversity in terms of achieving different minds and sort of having a Darwinian evolution of ideas. All that said, I do think that the problem that I sort of see society is that we are in what's called an airplane flying, chasing the needle. We are lurching from extreme position to extreme position. We are doing it too fast in a way that is possibly going to make the airplane crash. And that's not in anybody's interest. And I understand, the president's idea that he needs blitzkrieg, multi-front warfare to reverse years of problems, but to create as many problems as have been created over the past 4 months does not strike me as productive.
I don't think it's 4 months, Seth, but
Four weeks, yeah.
Well, thank you. Let me congratulate and thank the panelists. They were excellent. And let's move to the next panel, which is on immigration. And I want to introduce my other faculty colleague, Assistant Dean Anna Cabot, who's Professor of Law, Professor of Clinical Programs, and Director of our Immigration Clinic. Welcome, Dean Cabot.
Thank you very much, and welcome to the immigration policy part of this presentation. My name is Anna Cabot. I'm the director of the Immigration Clinic here at the University of Houston Law Center. I'm also the Assistant Dean of Clinical Programs. I'd like to introduce the panelists for this section. First, we will have Charles Foster, who is the chairman of Foster LLP. He will be discussing the new administration's policies, regulations, proposed and actual legislation as it affects legal immigration. Then we will have Professor Daniel Morales, who is Associate Professor of Law and the Dwight Olds Chair at the University of Houston Law Center, and he will discuss the interface and relationship between federal and state agencies, focusing on sanctuary city jurisdictions and the response thereto. Then we will have Gabriel Jack Chin, Professor Chin, who is the Edward L. Barrett Jr. Chair of Law and the Martin Luther King Jr. Professor of Law at the University of California, Davis. And Professor Chin will be discussing birthright citizenship. So I'd like to pass this to Charles Foster.
Okay, well, thank you very much. I'm pleased to be here. I've had a long association with the University of Houston Law Center, and in terms of my talk, it's more going to be focusing on the Trump administration's focus on what they ran on mass deportation as well as on legal immigration. That was, I think everyone who paid any attention would know that was a key part of the campaign, a promise, and promises made or promises kept. That's, I'm quoting President Trump right there. So we cannot, just yesterday I was in a meeting and someone said, well, he doesn't necessarily mean what he says all the time, and watch what he does. Well, if you watch what he does, I think it's pretty clear that he did mean that. The promise was based upon, as he repeatedly says, that the people who've been crossing our border without inspection were rapists, criminals, prisoners, the insane. And he promised to do something on day one, and he did. He signed multiple executive orders that I'll go over in a moment, covering various aspects. But part of that was not only to deal with the issue in fact and in perception, but to create what they admittedly wanted to do, shock and awe. And the purpose of that was a recognition, as I will get into in a moment, just how difficult it is to carry out mass deportation. So a big part of that is the expectation that we will have a lot of what's called self-deportation. People out of fear will leave the country on a voluntary basis. Now, when you do if you look at the polling data, when you just talk about mass deportation, it has big support. But when you look at the data, it's relatively limited. It focuses more on the mass deportation of criminal aliens. But when you talk about hardworking undocumented, then you get DACA beneficiaries and other classes, then you get different results in the polling data. As I mentioned, it's very difficult, easier said than done to have mass deportation. There's an estimate of 11 to 20 million in undocumented status. I think it's probably at least 13 to 15 million. And the ability to accomplish that is very limited for a couple of reasons. One, interestingly, the Trump administration does not have any more resources than the Biden administration. Now that can change because it is almost certain that they will be able to get legislation providing substantial additional funding in order to hire more Border Patrol, ICE, Immigration and Customs Enforcement officers, immigration judges, trial attorneys, asylum officers. But all of that will take a lot of time to find the people, hire the people, to train the people, and to get them on job. The other interesting part is, I think this was not widely recognized, both the Obama and the Biden administration, their immigration policy in terms of the use of limited resources was to detain and remove criminal aliens and those with outstanding deportation orders. So even though there was the impression given by the Trump administration that there was they had to get rid of all of these criminals, that had essentially been the focus of in terms of the internal enforcement policy of the Biden administration. And so there was another problem that the Trump administration's had, and that they wanted to get the numbers up, show that they were deporting more people. And the actual numbers are no greater than the numbers that had been deported in the same period of time by the Biden administration. So because they do that, rather than actually rounding up and deporting a lot of criminals, they're just rounding up for the most purposes, people that are here in undocumented status, maybe 10, 20 years or longer. And when the press secretary was asked about that, she rationalized and she said, well, they're all criminals, because if they came here without documentation, then they crossed the border illegally, they're criminals. And that technically she's correct. Crossing the border is a misdemeanor, although they were never prosecuted, and rarely are people prosecuted for that. The other thing to show how serious this administration is a significant reallocation of resources. They are reassigning, it's hard to believe, FBI agents, DEA agents, organized crime, drug enforcement task force members, Homeland Security investigations, even IRS agents, from criminal investigations to civil immigration enforcement, in part because they don't have enough people to carry out their quote mass deportation. Interestingly, or maybe some would say scary, the new Attorney General has issued a memorandum to all the U.S. attorneys throughout the United States, prioritizing immigration criminal prosecutions over every other class of criminal prosecution. That would be primarily under Section 1304, failure to register. I'll get into that in a moment. And scary for many employers, Section 1324 for harboring. Rarely, when employers when there's worksite enforcement audits, that is treated in civilly, but more and more it appears that there will be harboring charges brought against employers as well. Possible utilization of the U.S. military. We'll see about that. There are legal issues with that, but there's been talk in various papers, I think about the possibility of invoking the Aliens Enemies Act of 1798 and calling what's going on at the border an invasion. Although, interestingly, the Trump administration at the same time is bragging about the crossings being at a low, historic low. And as I've already said, there's a big emphasis on self-deportation. The new Attorney General's Attorney General Kristi Noem has put out a video. They're going to have a massive multi-million-dollar ad campaign in English and campaign telling everyone in the U.S. If you're an undocumented status, we will fine you, we'll catch you, we'll deport you, and you need to leave now. Before we do so, go back home, and then you can return legally. That would, I don't know whether anyone is, in terms of the media, following up on this, but that would normally be false advertising, because there's no way, if you look at the vast number of people that are here in undocumented status, they would not have had any legal way to begin with to enter. And once you enter and you're out of status for more than a year, you're subject to a 10-year bar. So to say to go leave and come back legally is really misleading. That's not to say some individuals will not want to go home or should go home. That's a different matter. I've already talked about the fact that I think this is going to be a big part of enforcement. More employment verification audits of the I-9 forms. Every employer is required to do that in order to determine and find undocumented workers whose documents that were provided, like the Social Security card, facially valid, but it turns out that the number doesn't match a real number. And then those individuals, we're going to have what we haven't really had since George W. Bush was president, and I worked for him. More worksite enforcements, the colloquial term for that is raids surrounding a business. Technically, they need a warrant, probable cause. Probable cause is normally not there, and back then, the typical way they got it was simply to yell "migra, migra," and those that ran gave them probable cause to stop and arrest. One or more states have already enacted laws, and there are proposed laws in different states, maybe a federal law, to enact bounty programs where our fellow citizens would be paid bounties to turn in undocumented workers. So again, it's going to be difficult to accomplish, but it's clear that this administration tends to do that. I've already mentioned the fact that the detentions and arrests in the U.S. are about the same. Border crossings are at all-time low. So maybe if they cannot find enough undocumented, they will create more, and that's exactly what's happening. A lot of programs have been canceled. The cancellation of the Cuban, Haitian, Nicaraguan, Venezuelan program, 30,000 under certain conditions were being admitted a month. Related programs for Ukrainians, Afghans are being canceled. Those that entered in parole status, a temporary legal status, that status can be canceled, and those statuses are being, apparently will be at some point canceled, but in the interim, CIS, Citizenship and Immigration Service, has been told to stop processing any benefits. The benefits, primary benefit would be to apply for asylum, applying for employment authorization, canceling temporary status programs for Venezuelans, Haitians, and presumably for others down the road. The administration will no longer defend the DACA program that's on its, maybe its ninth live in the Fifth Circuit, and that almost certainly the Fifth Circuit will find that President Obama, President Obama and then President Biden acted beyond their legal authority, and that will go up to the Supreme Court. The most interesting thing is there has been a law in the book that has not been enforced essentially since World War II, requiring all aliens to register unless you're already as a foreign national in the system, such as individuals that were admitted legally on a temporary work visa as legal residents. You're required to register, and that creates and a failure to do so is a crime, and that creates a Hobson choice for undocumented. If they do not register, they could be subject to further criminal prosecution, remembering that all U.S. attorneys are now incentivized to bring more criminal prosecutions, but it's a Hobson choice because if they do register, they're essentially surrendering themselves or giving the government information as to where they are, and there'd be evidence that they're undocumented. They're also canceling student visas for students that participate in anti-Israeli protests, or whatever you think about that. We would normally think that's covered by the First Amendment, but nevertheless, that is happening. And something that's very big, the expansion of expedited removal, which has always been used, it's been in the law since 1990, since 1996, excuse me. And it now allows the ICE, Immigration and Customs Enforcement, to remove someone wherever they are within the country without giving that person the right to defend themselves in immigration court if they have been here for less than 2 years. And one of the problems with that is that the average person detained would not have on them the evidence or the ability to prove, or perhaps to prove that they had been here longer than 2 years. Now, with all of that, executive orders can be enjoined, and that's what by lawsuits, and that's happening. Lawsuits have already been filed on behalf of the TPS Venezuelan program. And last Friday, a lawsuit was filed to reinstate the parole programs that had been canceled, and we could expect that to happen. Now, very briefly, when we talk about mass deportation, I'm going to deal with this in just in a sentence. We should step back and say, even if that were possible, is that a worthwhile goal, given the fact that we're a shrinking country? We need people, we need high-skilled workers, we need skilled workers, we need people at the bottom of the food chain also to work. We have essentially, we're at 4% unemployment. There are not a lot of people looking for jobs. And it begs the question, if we removed all those people, who would do the jobs? And many industries, as indicated, would be devastated. And in the end, the solution is comprehensive immigration reform, something I've worked on since 2000. Finally, on the impact of, in just a few words, of the Trump administration on legal immigration, that was not the focus of the campaign, but in the first Trump campaign, they had a greater impact on restricting legal immigration than they did on undocumented. And already the Trump administration is off focusing on legal immigration. They've canceled the legal immigration refugee program. They have executive orders saying they will no longer recognize give due deference to prior decision. What that means is we get a case approved for a temporary work visa for an artist, for a researcher, a ballet dancer, and then you file for an extension, which should be renewal, should be routine, but they come back and say, well, originally we found this person, this ballet dancer, to be of extraordinary ability, but now we don't. There will be stricter and more repetitive security checks that will slow down processing. Of greatest concern is the H-1B program is under attack by many people within President Trump's party, and most people do not realize how critical that is. People want people to be legal, but the H-1B has been the primary pathway by going from being a student with work authorization to getting temporary work visa status, and then the employer sponsoring them, going through a much lengthier process to sponsor them for permanent residency. The TN work visa possible under the U.S. Mexican-Canadian agreement, it may be in jeopardy. That helps professionals from Mexico and Canada to be able to qualify to work here. And there's been talk about, ironically, pausing all adjudications as long as we have backlogs. That doesn't seem like the proper way to deal with that. The proper way would be greater funding for more adjudicators. Again, we're concerned about any pause based upon on that basis or because of alleged security and fraud concerns, which at best are greatly exaggerated. So I'll just conclude by saying there's been a lot going on. I expect there will be more, so stay tuned for a wild ride. Thank you.
Thank you so much, Attorney Foster. I'm going to hand this over to Professor Morales.
Thank you all. It's wonderful to be here. So today I'm going to talk a little bit about what I'm calling the legal underpinnings of sovereign citadels and sanctuary cities. What I'm trying to focus here on is the legal foundations of controversies surrounding local immigration control efforts, local and state. I'll briefly touch on the history of local and state control, the consolidation of national control, and the legal foundation for modern sanctuary jurisdictions, and also the foundations for what I call sovereign citadels like Texas. I'll then discuss the efficacy and relative power of both models of local control in light of the ultimate fact of federal supremacy over migration issues. So before I do all that, though, I do want to spend just a minute setting the terms here and reminding us about sort of who immigrants are and what we're talking about. Undocumented immigration, or as many call it, illegal immigration, is truly one of the most polemicized issues of our time. And to turn down the heat a bit on this issue, I like to try and just remind people of the moral arbitrariness of nationality, of where you're born. No human being, not a single one of us, decides or even has a say in where we're born. We just appear on the face of the earth from our perspective. And yet, the place where we're born has profound implications for our life prospects and well-being. It's important to remember differences in income between countries are massively larger than income differences within countries, as are the availability of amenities essential to human thriving, like public education, running water, and electricity. And that's not even to mention opportunities for developing and using one's skills to the utmost in the short time span that human mortality offers to us. So whatever your views on the wrongness of undocumented immigration, I just ask that people consider and take into account the moral arbitrariness of our world of nation states as you formulate your positions. All right, with that to the side, let's talk briefly about the structure of immigration control and its history. It's important to note a little-known fact that for much of American history, states and localities were in fact in the driver's seat when it comes to immigration control. The border states of the early 19th century were largely New York and Massachusetts because people arrived by sea. These states sought to regulate migration not with the modern technology of visa and passports, but largely based on the wealth and health of immigrant entrants and through tools of taxation like the imposition of a head tax on immigrants arriving by boat and the refusal to admit to ports of entry immigrants who appeared, quote, likely to become a public charge. Given the non-existence of national programs supporting public health or the indigent in the early 19th century, the tax revenues states collected were used to feed and house those immigrants that did not initially make a successful go of it in their new homes. In the 19th century, states even ran deportation programs. Massachusetts at the state level did so with state authority, and New York City did so at the municipal level illegally against state authority. In both cases, immigrants that were considered destitute or with criminal backgrounds were shipped back to ports in the old world. It's worth noting that these deportations were not very discriminate, much like many deportations today. They often native-born American citizens were deported to places in the 19th century that they had no relationship to. And native-born and naturalized citizens were deported during that period by states like New York and Massachusetts. Some of this encountered public pushback. A lot of it didn't and flew under the radar. Okay. So the cruelty, arbitrariness, and lack of due process in these state-run systems ultimately spilled over into the structure of national control when national control emerged with the Page Act in 1875 and the 1882 Chinese Exclusion Act, which barred the admission and naturalization of Chinese subjects. As well as one less noted law, the Immigration Act of 1882, which provided the first national grounds for exclusion of non-citizens from entry. And this law barred so-called paupers and those with criminal records from entering. Even as the regulation of immigration became nationalized during this period, it still actually bore the mark of the states that did the regulating before the feds took it on. In particular, state personnel, especially officers at ports of entry, were hired or contracted to administer the national immigration laws. Additionally, it's important to note that the harsh strategies, and some might say overbroad strategies, that states like New York and Massachusetts had invented to regulate immigration, particularly the virtually unreviewable discretion of the officer at a port of entry to deny admission based on his determination of who is a pauper or a public charge. Those were all sort of taken up in national legislation in the late 19th century. So in many respects, whatever your views on the merits of policies pursued by sovereign citadel states like Texas or sanctuary cities or states like California, the effort and desire both to control immigration policy within state boundaries and to influence federal policy in a direction that states approve of is a very old story. I think this is worth remembering or noting because today it's sort of common sense that immigration is a fundamentally national issue. But there has in fact always been a tug of war between states, localities, and the national government over their preferred immigration policies. And so similarly, as there's sort of this long history of harsh treatment towards immigrants, there's also a history of state and local treatment of immigrants that we might say corresponds more with what sanctuary city jurisdictions and state jurisdictions are doing today. So the history of state and local resistance to deportation is less well known. A particularly interesting period comes in the 1920s and 30s. This was the era where Congress passed a law called the Quota Acts, which historian Aristide Zolberg has said made immigration from Europe disappear virtually overnight. Deportations were also ramped up of Mexican nationals in Texas and other states along the US-Mexican border, and also in northern cities. Historian May Nye recounts that in those northern cities and states in particular, white European immigrants in the 1920s and 30s were actually viewed as members of the body politic, even though they were non-citizens. And that as the national government moved to deport more of these European immigrants who were the illegal immigrants of their day, just as today for having no papers or the wrong ones, local and state governments and civil society organizations rose up to defend those white European illegal immigrants from deportation, and they did so with significant success. So for example, in one emblematic case, the governor of New York moved to pardon an Italian immigrant to Buffalo who was being deported by national immigration authorities because he was convicted under New York state law for stealing half a bag of coal, quote, half a bag of coal from the railroad tracks to keep his family warm, end quote. And he did this actually when he was a boy. The national authorities wanted to deport the grown man and father of three because they viewed the theft conviction as a crime of moral turpitude that rendered any immigrant deported under national law. And by the way, this statute is still on the books. So by pardoning the state conviction, the governor was able to halt the federal decision to deport. And some states, including New York, did this at scale, so this wasn't sort of a one-off. This became more routinized during this period. And so the effort to treat immigrants like permanent members of our society in certain states and localities was not limited only to these most sympathetic cases. In New York State, again, quoting Mae Ngai, many convicted felons received executive pardons after they served their prison terms in order to prevent their deportation. So rather than seeing criminality as a basis to send someone back to their home country, these states decided that they would pardon them after they served their term so that the national government could not deport them. Eventually, the desires of states and localities to prevent the deportation of even those guilty of not just not having papers, but crimes against property and even persons did trickle up to the federal level. The Immigration and Naturalization Service at the time began to use clever interpretations of statutes to give immigrants convicted of crimes reprieves from deportation and even access to green cards. And the INS at the time thought that this was serving the purpose of family unity, among other values. It's important to note that very little of this grace from the national government or state governments was bestowed on Mexican immigrants at the time who arrived via the U.S. southern border. Their trespasses, so to speak, were never forgiven. Their families being separated were not viewed as by our society as hardships to avoid, again, following Mae Ngai's work. Okay, so more recently, of course, many states and localities have refused to cooperate or lend a hand to federal deportation efforts. These localities and states are known as colloquially as immigrant sanctuary, but it's important to note that this is a bit of an aspirational misnomer since cities and states cannot actually serve as proper sanctuaries since they usually and only quite rarely can override the national government's decision to deport a state or local residents. The main power that states and localities have when it comes to immigration is the power not to cooperate or lend a hand to federal efforts. And this refusal to cooperate means that the federal government must then work harder to deport an individual non-citizen, especially because contact with local and state criminal law enforcement is usually the main trigger of deportation. Okay. So where does this right come from that sanctuary cities are using? Well, the right not to lend state and local resources to federal efforts is grounded in the constitutional anti-commandeering doctrine. And this doctrine is a species of structural federalism. And it's worth noting, it's not a doctrine that's grounded in the constitutional text, but it's one that the court has read into the Constitution and expanded on in the last few decades. The basic principle of anti-commandeering is that Congress cannot, consistent with the doctrine, use local resources to advance federal prerogatives or policies, or direct state legislatures to pass, or more recently not to pass, legislation. So a key case in this anti-commandeering doctrine involved the Brady gun control laws, temporary use of law enforcement officers, local law enforcement officers, to enforce its gun purchase background check provisions. The Supreme Court found that the use of local officers to enforce the federal law violated the Constitution because the national government was commandeering local resources, that is, eating up local officers' time with federal tasks, and made local officers into the face of federal gun control efforts, potentially tricking local citizens into thinking that local or state government was responsible for the law. For the same reasons, local and state police officers cannot be pressed by the national government into enforcing national immigration laws. Certainly, those officers may, if with state and local approval, volunteer to do so with federal agreement, as many law enforcement agencies in Texas already have very recently under 287G of the Immigration and Nationality Act. Since there are many more locally and state-controlled police officers than there are federal immigration enforcement officers, non-cooperation keeps the national government's capacity to deport lower than it would be without the constraints of constitutional federalism. So just to expand a little bit, yet another wrinkle in the anti-commandeering doctrine emerged with a more recent case called Murphy v. College Athletic Association. The holding in Murphy extended a different line of anti-commandeering cases, rooted in the notion that Congress could not direct or commandeer a state legislature by telling that state legislature that it must pass a statute. Murphy then extended that principle to its opposite, ruling that Congress also could not bar state legislatures from passing legislation on a particular topic. In the immigration context, there's been significant litigation related to an information sharing provision of 8 U.S.C. Section 1373. That provision purports to bar any government entity from prohibiting or in any way restricting any government official or entity from sending or receiving information from federal immigration authorities about immigration status, lawful or unlawful, of an individual. So this expansion of the anti-commandeering doctrine in Murphy, and it was a recent expansion, led courts in California and Illinois to find Section 1373 unconstitutional. This too fortifies sanctuary jurisdictions and give them legal grounds to resist cooperation with the national government. So just to sum up, as you can tell from this brief overview of the history of state and local action and a brief description of contemporary issues, immigration law and enforcement has long been an area of active state and local involvement, both to protect immigrants and to expel them from state and national shores. It remains, however, the case that there's a fundamental asymmetry in local power in this issue. Sovereign citadel states like Texas, whose government favors more and stricter enforcement, can actively work and commit resources to achieve their policy goals, as Texas has with Operation Lone Star, for example. Sanctuary jurisdictions, however, are fundamentally barred from achieving their ambition to protect their residents from deportation by federal supremacy in this area. So whatever the rhetoric surrounding this issue, Texas and other states with similar political orientations today do enjoy a structural advantage, in my view, of their counterparts in the immigration, over their counterparts in the immigration federalism arena. Thank you so much.
Thank you. I'm now going to pass the mic to Professor Chin. Thank you.
Thank you. Can you see me in my slides?
Yes.
Great. Well, it's a pleasure to be here. You've heard that there have been a number of fairly momentous executive orders in recent weeks. I'm going to talk about another one of them, President Trump's birthright citizenship executive order, which came out on the first day of his term, January 20th, 2025. And it says that a number of people who previously had been thought of as U.S. citizens will no longer be treated as U.S. citizens under his order. In particular, if a child born in the United States has a father who's not a U.S. citizen or lawful permanent resident, and the mother is either unlawfully present or temporarily present, even if lawfully, in those circumstances, that child will not be a citizen. Mother unlawfully present or temporary lawful presence, and father not a citizen, not a lawful permanent resident, then the child born in the United States previously would have been treated as a U.S. citizen, now not. This is a significant thing, because if you're not a U.S. citizen, you do not have the right to remain in the United States. If you're not a U.S. citizen, there are a lot of jobs and contracts and security clearances and economic rights that are not available to you. The executive order says that it's not going to go into effect until 30 days after January 20th, 2025. But there's no law or constitutional amendment that is coming into force then. So if this executive order is valid, then it would seem to apply before and after the executive order. That is to say, the executive order purports to interpret the freestanding Constitution, a provision of the Constitution that we're going to talk about. And so it would seem, in principle, to apply to everybody who's not a citizen since 1868, when that provision of the Constitution came into effect. It's also the case that there's no explicit principle or rule in the executive order itself that says why it drew the lines that it did, or why it made the decision that it did. So it's somewhat mysterious as to the full scope of the idea behind the executive order. The executive order has not gone into effect because lawsuits in California, Maryland, Massachusetts, and New Hampshire have resulted in a nationwide injunction. I want to talk about what is going on in the executive order. The background is that there's nothing in the Constitution or in the early federal statutes passed in the early United States that talks about citizenship by birth in the United States. There is a statute that allows people born outside of the United States to become naturalized citizens. There are other statutes that allow children of U.S. citizens born overseas to receive citizenship, but there's nothing explicit that says who, if anyone, born in the United States is a U.S. citizen. And yet we assume that lots of people born in the U.S. after 1776 and before 1868 were citizens. There must have been. What happened in 1868 is the 14th Amendment, and the Citizenship Clause of the 14th Amendment grants citizenship to all persons born or naturalized in the United States and subject to the jurisdiction thereof. And this was obviously intended to overrule the Dred Scott decision that said no person of African ancestry could be a citizen, even if born in the United States. It was designed to give citizenship to the formerly enslaved people, plus the free persons of color who existed in the United States. The hard part, the tricky part of the statute, of the Constitution, is what does subject to the jurisdiction of mean? Who are the people who are subject to the jurisdiction of the United States? The issue came up in a case called United States versus Wong Kim Ark in 1898. And the issue was whether a Chinese child born in the United States was a US citizen. This was a government appeal, so it was kind of like the executive order here. All the courts and the lower court in Wong Kim Ark itself said that based on the 14th Amendment, Chinese born in the United States were US citizens. Government didn't like that, so it appealed to the US Supreme Court. This is the law that they gave us. They said, look, before the Constitution, before the United States, in England, the common law rule was that a person born in the king's dominion was a subject, with two exceptions. Children of foreign ambassadors and children of alien enemies in hostile occupation of the territory. Those people were not citizens because the king did not have their allegiance, obedience, power, or, as we would say in this day, jurisdiction. Children of foreign ambassadors were not subject to British law. Children of alien enemies in hostile occupation of territory claimed by Britain were de facto not subject to the control of the British authority. So those children were not subjects, and that law, the Supreme Court said, was comprehensive. Everyone born in England is a natural born subject unless they're the child of an ambassador or an alien enemy. What about the United States? Well, they said the same rule was in force in all the English colonies. Same rule was in force in the United States at the time of the Declaration of Independence and the Constitution. And they said the same rule was reaffirmed in the 14th Amendment, Section 1 of the 14th Amendment. So they said, this is the policy. It's straightforward, plain and simple. The curveball that came into this, and really, I think the only significant opposition to this idea from a court, from a scholar, from Congress, from anybody, came in 1985. My former professor, Peter Schuck, and Roger Smith, a political scientist, wrote a book called Citizenship Without Consent, Illegal Aliens in the American Polity. And they made 2 points. One is they said there were no unauthorized migrants in 1868. We had open borders, as Professor Morales pointed out. So the 14th Amendment can't have been intended to grant citizenship to the children of unauthorized migrants in 1868 because there were no unauthorized migrants. It's a concept that didn't exist. The second thing they said is, okay, there's English common law, and that's great, but we are the United States. We're not the United Kingdom. We're not a feudal society. We don't have a king by the grace of God. We're a republic, and citizenship is not like subjectship. Citizenship, they said, should be based on a decision of the people. So that was their argument. And there was a lot of pushback to this, including by me. And I wrote a paper which with another scholar, Paul Finkelman, which was based on a observation by Professor Gerald Newman at Harvard. And that is, there were unauthorized migrants in 1868. Indeed, unauthorized migrants were intended to be among the main beneficiaries of Section 1 of the 14th Amendment, namely children of persons of African ancestry brought to the United States in violation of the slave trade laws. And in this paper, we go through the slave trade suppression laws in the United States in some detail. And in 1819, for example, well before the 1868 Constitutional Amendment, a law was passed that said when unauthorized migrants, when slaves brought here in violation of the slave trade laws are found, they are to be arrested, they are to be transported to Africa. So there were people who were not allowed to be here and who, if they were captured, had to leave. Here's a US District Court case from 1860 explaining that the law provides for removal of unauthorized migrants found in the United States in the form of enslaved people unlawfully trafficked to the United States. Some of you, many of you may be familiar with the Amistad case, which was the subject of a Steven Spielberg movie. That was one of the issues in the Amistad case. The district court in that case ordered the African people who had taken over a slave ship and transported it to the United States. He ordered them deported to Africa. And they said, we don't want to go to Africa. We're not from Africa. Don't send us to Africa. And the Supreme Court said that under the circumstances, since they weren't brought here in violation of the slave trade law, they didn't have to be deported to Africa. Now, I told you that the executive order itself does not explain the basis of why some people get citizenship and some don't. But some of the Department of Justice oppositions to the lawsuits brought against it in the last several weeks say that the rationale is based on allegiance. If you are a citizen of another country by law, then you are not subject to the complete jurisdiction of the United States. If Japan or Italy or Brazil makes you a citizen of their country at birth, then you're not subject to the complete jurisdiction of the United States, and you're not a citizen. That issue came up in Wong Kim Ark. Supreme Court addressed it, and they said, if that's true, then the children of English, Scotch, Irish, and German people would not be citizens of the United States. They also said, we reject the idea that foreign law is going to be the determinative factor in American law. We make our own citizenship rules. We don't care what other countries do. That's their business. Our business is our business. But do note the consequences of the Department of Justice argument if it were true. If it were true, then let's imagine the great-great-great-grandchildren of these of a person, all of whom's ancestors, original ancestors, were immigrants. Well, the immigrants aren't citizens, their children aren't citizens, their grandchildren aren't citizens, and their great-grandchildren aren't citizens. So many people in this room or on this call, if all of your ancestors were immigrants, then if this allegiance theory is true and were not naturalized before they had your first ancestors born in the United States, then you're not a citizen, because the children, the first generation born in the United States, was not subject to the complete jurisdiction of the United States and therefore are not citizens. But as I say, Wong Kim Ark considered and rejected that idea. The other theory is that there has to be consent, and one can say that that's a good theory and a correct theory, but it does beg the question, isn't Section 1 of the 14th Amendment democratic consent under our society to everyone who's born in the United States being a US citizen? And certainly there are administrability and determinability reasons that it would make a lot of sense to say, if you're born in the United States, you're a citizen. The last thing that I'm going to say is I'm confident that this law will not be upheld by the executive order will not be upheld by the Supreme Court. And the reason is that Congress has, on many, many occasions, passed laws based on the assumption that Wong Kim Ark is good law, and that the many decisions of the Supreme Court and Department of Justice that say that any person born in the United States is a citizen regardless of the citizenship or immigration status of the parents, with the exceptions outlined in Wong Kim Ark. So the Supreme Court is going to say, unless Congress passes a law, they're going to say, whatever the freestanding Constitution may or may not mean is one thing. But Congress, which unquestionably has the power to make citizens, has assumed this and legislated in light of this, and legislated a structure that really requires that everyone born in the United States be a citizen. And so if anyone is going to change that, it's going to have to be Congress, not an executive order. Thanks.
Okay, thank you. I'd like to invite the panelists back to the kind of back on video. I have some questions, taking my moderator duties seriously. In fact, my first question goes to a theme that all of you have kind of touched on, is this new administration has propounded, has articulated things that it does not seem like it has the capacity to do. And Attorney Foster touched on this in terms of the scale of mass deportations, and Professor Chin also just touched on this. And Professor Chin, I just wanted to ask this question as it relates birthright citizenship, and everyone feel free to respond as well. But the decisions that I've read, and the kind of the articles about the decisions I've read that have, as you said, pointed out that this is unconstitutional, have all been very emphatic. And there was, this seems like a foregone conclusion, this finding that this executive order was not constitutional. So what is the silent part here? Why do you think this executive order was written?
I think it scores political points. And frankly, I say this with a very high level of ignorance, I think it's a gift to Chief Justice Roberts. because there are a lot of things that are going to get upheld. And I appreciate Professor Morales and Mr. Foster's discussions of some of the changes that we may be in store for. And there's a lot of harshness that the president does have discretion to impose. And that's going to get upheld if it's legal. But this is going to be an opportunity for the Supreme Court to look moderate and balanced, because they're going to say, we're not going to do this.
Does anyone else want to weigh in on this?
I mean, I agree with Professor Chen. I do think it's a symbolic effort. Not that symbols don't matter, they matter a lot. And I think they matter a lot to folks who, his supporters in particular. And so, I mean, I view it as a sort of a pair to EO1 from his first term, right? So the first executive order that President Trump imposed in 2016, was it that long ago? Was the Muslim ban order. And in my view, that order also, I mean, of course, again, when I say symbolic, I don't mean it doesn't harm people. I just want to be clear. But again, I felt like that order was about sort of reestablishing sort of supremacy of a particular traditional, quote unquote, group of Americans above others. And that was one of its primary purposes. And I view the birthright citizenship point, notwithstanding, I think, Professor Chen's correct analysis that it would imperil many people who believe themselves to be sort of old American stock, so to speak. I think that it is meant to be, say that these are the real Americans, not these other people. And I think that's a powerful part of President Trump's appeal.
Thank you. I have a question from the Q&A, a question from the audience. How far can the de facto power from combined state and federal efforts go without getting checked? And more specifically, are migrants' standing or other legal features changed if they're successfully removed to Guantanamo or to Panama? And this is a very interesting question about
I can certainly take the state and local, but the Guantanamo one, I'm going to have to leave to somebody else. But with the state and local, I mean, I think Mr. Foster pointed out very clearly the capacity issues that the administration is facing. And those are the primary issues with respect to their goals. And I think if there's going to be a check, it's going to, and frankly, I think this is true for everything the administration is doing. If there's going to be a check, it's going to be from the people themselves, either by, I mean, there was a moment of horror in the last Trump administration when the family separation policies emerged. And I think they were stopped in large part because of public horror at the violence of those policies. Now, of course, the person who executed those policies and came up with them is now running the agency. So, but that doesn't mean that people still can't be upset and that won't have any effect. So I think that's, politics is the main limit. I mean, I think, unfortunately, or fortunately, depending on your perspective, I don't know how powerful that is going to be this time around. It remains to be seen. But I don't think there are a lot of structural limits beyond the capacity limits that Mr. Foster pointed out. Maybe others feel differently.
I might use, we're talking about the children in cages, how that created pushback.
Yeah.
I think we could have a big pushback because, as I pointed out, this administration, they seem to be determined to remove large numbers of people. And I think at some point it's going to begin to impact a lot of employers, as I mentioned, in construction, housing, hospitality, and particularly if U.S. attorneys are pressed on the number of criminal immigration prosecutions and they start prosecuting employers for harboring, I think finally the business community may get more engaged and make this a bigger issue than they have been willing to do so in the past.
Just to fortify Charles's point, I mean, I think Texas Monthly reported that 40% of the Texas construction industry is undocumented, for example. And, you know, Texas relies on building a lot of houses to attract people to the state. And I think the costs of that, frankly, just the ability to build is a huge part of Texas's appeal. So even here in Texas, I think there will be some pushback should the numbers actually start getting hit in significant amounts. I agree.
All right, I'd like to thank our panelists for this very informative discussion and pass the mic to Professor Pinto and the final panel on energy and environmental policy.
Hi, everyone. Welcome to the Energy and Environmental Policy session. I'm asking the panelists if you can turn on your cameras and for the introductions, and we'll get moving shortly. So I'm Pablo Pinto. I'm a professor at the Hobby School of Public Affairs, where I direct the Center for Public Policy. So it's a great pleasure to introduce today our distinguished speakers, who will discuss critical land use, environmental energy policy issues. Our first speaker is going to be Dean Marceline Burke. She's the Mitchell Franklin Professor of Law and Dean of Tulane University's Law School. She's an expert in property, land use, and environmental law. And she brings years of experience in both academia and government, where she served as Assistant Secretary of the U.S. Department of Interior. The second speaker is going to be Professor Tracy Hester, who teaches at the University of Houston's Law Center, and is co-director of the Environmental Energy and Natural Resources Center and the Center for Carbon Management in Energy at the University of Houston. His research focuses on climate engineering, decarbonization, and environmental risk and liability. And his work has shaped how legal frameworks adapt to modern environmental challenges. Our third speaker is going to be Professor Gina Warren. She's the L.A. O'Quinn Chair in Environmental Studies and co-director of the Environmental Energy and Natural Resources Center. Her internationally recognized research examines the intersection of environmental, energy, and property law with social justice issues. The session will start with presentations by the three experts, and that will be followed by Q&A. So I encourage all participants to post your questions in the Q&A tab. So let's begin the discussion with Dean Marceline Burke. And it's like, the floor is yours then. It looks like you're muted.
There we go.
Okay.
Good afternoon, everyone, and thank you for this opportunity to share. And I am having technical challenges with my new laptop, so how about that? But let's see if we can get it to, there we go. All right. So thank you, everyone, and thank you for this opportunity. Thanks to my friends at the University of Houston to engage in this really important conversation. And I say this is an inside-outside look at these bureaus because I have not talked to anyone. So this is really just me and basing it on my experience as the political deputy director for the BLM and then as the acting assistant secretary for land and minerals management, so overseeing all of these bureaus. And so, as you know, with every administration change, right, especially when the White House shifts from one party to another, you're going to see significant shifts in policy, priorities, and personnel. This is no surprise to any of us. And when I look back at some work that I did in the first administration, and I expected to see much of the same. And we have seen much of the same, that being shifts in regulatory focus, Drill Baby Drill is back. The first secretarial order, rather the first executive order, which then was followed by a Department of Interior secretarial order, Unleashing American Energy. This is all very familiar to us. And then the reconsideration, or some might say the abandonment of climate and conservation initiatives, and one of the more significant ones being the proposal from the Council on Environmental Quality to roll back the implementation of NEPA, the National Environmental Policy Act. There's also an emphasis on state and industry partnerships and creating a more favorable environment for industry. And finally, we see personnel and institutional resistance, right? So in the previous administration, we saw a tension between the political leadership and career staff, which led to departures, as well as reassignment of employees who resisted deregulatory efforts. Now, this movement has the potential, of course, to impact agencies' efficiency as well as the morale of the workforce. So how is this one different? And oftentimes we hear with a change of administration, you know, there's a new sheriff in town. And I'm like, this is a new sheriff in town. There's some notable distinctions here from the first term, and I'm really going to focus on the impact on employees. And you might think, you know, what is this of consequence to me? Well, particularly if you're going to be dealing with the agencies, I think really taking into account and consideration how they are impacted will inform your strategy on how to deal with the agency and your representation of your clients. So of course, here, as we've been talking about all day, there's been much more aggressive policy implementation. For example, with offshore drilling bans as well as onshore orders to increase increase development on federal lands. And then, of course, there are the structural and staffing overhauls. In the first administration, headquarters of the BLM, for example, was moved to Grand Junction, Colorado, a lovely place. However, some might say impractical for the actual work that is done in headquarters. And the idea was that the land is out west, so why aren't the headquarters out west? Well, most of the employees are in fact out west, yet the headquarters work very closely with Congress and other entities within Washington. And so they were moved back. So now they're talking about moving them out again. And there's this atmosphere, obviously, among all federal employees about this uncertainty and concern that they have become the enemy and that they are being vilified. And this, of course, is going to have an impact on how they do their jobs. And as I thought about this presentation, I thought in my head over and over about conversations that I had with career employees during my time at the Department of the Interior. And I have the utmost respect and admiration for those individuals that I worked with during that time. When I first started, and there was a retreat for the political appointees, the Secretary of the Interior called us the Dream Team. So you remember 1992, the Olympics, the Dream Team, called us the Dream Team. And one day I was talking with one of the lawyers, and I said, you know, hey, we're the Dream Team. And she said, no, we're not. And so I reflected back to the one training I had as a senior executive service member. And the only thing I remember about that training was that they said, career employees look at political appointees and all they see is a clock on your forehead. The clock being that you will be here for a very short period of time. I think the average at the time when I served was 14 months. I went way over the hill with 42 months, but most people do not serve in these political positions, particularly unless you're the secretary, the head of an agency, for very long. And so if there is policy resistance, the idea is that they can wait you out. They can drag their feet and make it difficult for you to make any real change, recognizing that time is short. Now, I didn't actually experience this during my time. And so I was saying to this person, no, we're the dream team. And she said, no, you're the A team and I'm the B team. And I said, what does that mean? She says, we be here when you be gone, right? Recognizing that they have longevity. They are the ones that carry the continuity of the agency, the policy, the programs, and political appointees come and go. Well, of course, this time around, that idea has been completely upended to the point that the Public Lands Foundation, for example, which is the Bureau of Land Management's retiree group, posted a statement in support of civil servants, really concerned that their worth was not being appreciated as it should. So there are a lot of pros and cons to this approach, this rapid fire change. And absolutely, it is a delivery on promises to have an aggressive approach to decision-making and eliminating bureaucratic roadblocks to really promote development of natural resources. It provides some certainty to industry, knowing that they're likely to have more favorable decisions with respect to permitting and leasing, for example. And it can potentially give power back to the states to have greater control over land use management that reflects their local economic and political interests. At the same time, however, there are lots of disadvantages to this approach. And we're thinking on the outside that we're reeling from all of these changes. Imagine if you're on the inside and you're trying to actually implement all of these changes. These rapid policy reversals, as we know, it's going to lead to lots of court challenges and regulatory instability. And the employees are trying to balance all of this, the political directives and the established regulations. So if you are before one of these agencies, think about the fact that because they're unsure about the long term, they're going to be hesitant to make firm commitments or decisions today, right? Also, they may be overburdened, as the last panel, for example, was talking about, with this desire to get lots of work done and get it done quickly, and at the same time, dismissing employees. At least in the short term, employees are going to be overburdened with the increased workload. And so they may not have the bandwidth, even though they have the policy directive, to move matters along quickly. The other point here, and I'm not sure that this happened the first time around, is that there has been the termination of these advisory committees, which limits public participation in the process, advising the agencies on how they do their jobs. And getting rid of those absolutely will erode stakeholder trust over time. So there, obviously, we talked about, there are lots of changes here. And I think that it's important in dealing with agency employees to actually acknowledge the challenges that they are facing and recognize the pressure that they're getting from competing stakeholders in a way that they may have never experienced before. And in fact, concerned about whether or not they will have a job tomorrow, notwithstanding the fact that many were called back to work as of today. So I just want to end this with thinking about, as we navigate through the impacts of these changes and how you might plan for them, because the balance between environmental, natural, and cultural protections will continue to be a contested space. And people who've taken great pride in the work that they do and the oath that they've taken, as I said, again, feel as if they are under attack. So keeping that in mind when you are dealing with them may help you move your matters along more quickly. So this is a roller coaster, right? And so whether or not you're the person over here that's like, wait, this is great, these are the changes that were long overdue, or the person that is horrified by what is going on, I say for sure that we all need to buckle up, because the political dynamics that are at play here, we don't know what the end will be. And with that, I will conclude my presentation.
Thank you so much. We're gonna move now to Professor Tracy Hester. Tracy, the floor is yours.
All right, thank you, Pablo. Just one moment while I go ahead and get my screen sharing going here.
I'll stay with you until you.
Okay. And hopefully everyone is seeing my PowerPoint now. Excellent. All right, well, hello everyone, and thank you so much for staying with us to the last panel. Very much appreciate your stalwart determination. I'm here to talk about climate policy under the new administration. I want to begin by first acknowledging it's a bit of a illusory line because energy and climate are obviously very tightly intertwined. Professor Warren will be covering some of the energy issues, but I think we'll find that there might be some intertwining of our two discussions. So with that in mind, I'd like to begin by setting the stage with just reminding us what the promises were when President Trump was campaigning for re-election, including a little bit look at what Project 2025 proposed, then compare it with what's actually happening now, and zeroing in on what the 3 or 4 most important, in my mind, for policy considerations changes are. And then last, if time permits, I might offer a bit of a parting thought on what this climate discussion actually means for the bigger picture of how we're actually going to be perhaps changing the engine under the hood of the administrative state for future transitions. So with that in mind, I don't think it's going to surprise anybody that despite the enormous amount of activity going on all fronts, including immigration, education, and every other front imaginable, climate is very much at the crucible of the new administration. This is the headline from the New York Times just a couple of days ago, emphasizing that it's not just 1 or 2 keystone battles. The entire front of every possible climate policy seems to be contested at the moment. And that's not surprising, considering that that was one of the keystone issues that President Trump campaigned on. And even though he forswore the relevance of Project 2025 to his campaign positions, nonetheless, you might take a look to see that there's a pretty sweeping game plan on how to change the United States climate policy. In particular, it called all across the board for de-emphasis of efforts to address climate change, including reorienting the White House's Office of Science Technology Policy, taking tighter political control of the Council of Environmental Quality, eliminating the work group that had been created to talk about social cost of carbon, which I'll get to in a little bit, and to stamp out climate advocacy in all foreign aid programs, including USAID, and to reorient the major substantive agencies, including the U.S. Department of Agriculture, Department of Energy, and Department of Transportation, to essentially de-emphasize climate as a policy driver, which was, of course, a hallmark of the Biden administration. And Project 2025 actually called for the outright dismantling of the National Oceanic and Atmospheric Administration. All of this, as you might expect, was just anteing up. If we were to stop and take a look, first of all, what I suggest is that I'm only going to give you a quick surface snapshot of what's going on. If you're interested, there are several trackers that are actually providing detailed, granular updates on exactly what's happening. This one is very good in terms of detail on what's actually happening at a regulatory level. Also, I'd strongly suggest the Federal Register is actually maintaining a separate web page now for all of President Trump's executive orders, which will give you the official dates of signing and proclamations, as well as pagination. And right now he's up to 76, which may not include ones that he's signed in the past day or two. That's obviously shatters any record for signing executive orders at the opening of a term. So if you took a look at all of those and tally them up, this is just a partial list of all the different climate activities by the Trump administration. We could literally spend the next 3 hours going through all of them. And instead, what I'd like to do is zero in and talk about some of the most important ones for policy issues. And more importantly as well, they also highlight different approaches that the Trump administration is taking to try and affect change. So I'd like to begin with the National Energy Emergency Declaration. This is an executive order 14156, that was actually signed on his very first day in office. I think it may have been the second one he signed. Or it certainly wasn't his first day. I'm not sure is that number. But the key thing about it was that it essentially invoked all of the White House's emergency powers under statute and its inherent Article 2 authority to direct agency-wide coordination for essentially ramping up on fossil fuel and energy production. And that had specific implications for climate decisions. Obviously, the two are each side of the same coin. The Biden administration emphasized clean energy as a climate policy. It makes perfect sense that the incoming administration would flip that 180 degrees. The key things in the emergency declaration are in Section 2. It specifically invokes emergency approvals of domestic energy resource development authorities so that agencies would essentially invoke portions of each major salient environmental statute that provide for relaxed permitting and expedited approval of projects that would be then used for energy production development. And for example, the order specifically points out to EPA to grant emergency fuel waivers for E15 fuels. Section 4 does the same thing, but for wetlands that might affect energy production development. Obviously, wetlands are a key part of climate policy as well. But this order directs the U.S. Army Corps of Engineers to aggressively use its emergency authorities under the Clean Water Act to essentially expedite nationwide permitting and site-specific permitting to allow development of energy projects that potentially would result in takings of jurisdictional wetlands, even the ones that remain after the Sackett decision a couple of years ago. And then Section 5 specifically invokes the emergency provisions of the Endangered Species Act, and including the convocation of the God Squad to expedite issuance of permits that even may jeopardize a protected species. Package all those together. And again, this is just an executive order, so it's directing agencies to start taking actions in this front. But as they proceed forward, they will translate those into regulatory and permitting actions. The whole order is keyed to the definition of energy, and energy is pointedly omitting any wind and any solar. It does include geothermal, it does include biofuels, it includes many other possible alternative energy platforms, but those two keystone climate technologies are intentionally carved out from the sweep of the order. That's just one. Number two, on the international scale, obviously, one of the very first things President Trump did was an executive order withdrawing the United States from the Paris Agreement. I think we're all familiar with some of the implications of that. It was on the front page for multiple times. He had done this previously in his first administration, although after a much higher degree of deliberation and contesting within the agencies. Bottom line is that the Paris Agreement is an agreement within the umbrella of the UN Framework Convention on Climate Change. The Paris Agreement essentially obligates the United States to commit to reductions of greenhouse gas emissions pursuant to its own nationally determined contribution. Bottom line is that withdrawal, according to executive order, is effective immediately. Now, he does not attempt to try and withdraw us from the UN Framework Convention on Climate Change, which was ratified 98-0 by the Senate. So it's a full-scale treaty. But the Paris Agreement is an executive agreement, which theoretically, under its own terms, gives the president the power to withdraw the United States with a 1-year grace period. So that will, even though it won't take effect for another year, it is already being, as pursuant to the term of the executive order, acting as if it has already been withdrawn as far as the United States is concerned. That may have implications, in particular for whether, example, the United States can and its citizens can readily participate in some of the carbon credit trading mechanisms being created under Article 6.4 for internationally transferable mitigation outcomes. But right now, we're just trying to see how things are going to be navigated with COP30 in Brazil at the end of this year. Number 3 is another fundamental change of direction. As we all know, the Clean Air Act gives EPA the authority to regulate greenhouse gases as a pollutant. That is a result of the Massachusetts versus EPA decision, which interpreted the term air pollutant to encompass greenhouse gases, but then also directed EPA to come up with a rationale on deciding whether or not those greenhouse gas pollutants endangered human health and the environment under Section 202 of the Clean Air Act. As a result of that remand back to the agency and additional work, after an extensive factual record, in 2009, EPA published in the Federal Register the endangerment finding, which concluded greenhouse gases did have that risk to human health and environment. So leaving aside a long story about some of the machinations, the bottom line is that despite multiple legal challenges, that endangerment finding has been upheld by the courts. And as a result, it's an interesting question because one of the first things the Trump administration executive orders directed was that that EPA reconsider the endangerment finding. It doesn't specify how, it doesn't specify what outcome. It simply directs them to reconsider. According to press reports, the EPA has already responded to that executive order and told the White House that the endangerment finding should be reversed. It doesn't say how, why, or in what way. At this point, we don't know what the next step is going to be or what the rationale is. There has been litigation filed by the Environmental Defense Fund seeking a FOIA request to compel production of that recommendation. But the bottom line right now is that under the endangerment finding, if it is subject to reopening, it's going to have some interesting consequences. In particular, for example, it may involve having to deal with some subsequent legislative activity by Congress, which seemed to implicitly accept or endorse the endangerment finding and the Inflation Reduction Act. In addition as well, EPA has made several endangerment findings in other subsequent rulemakings. So it's not just one. We're going to go back and revisit each of them, perhaps collectively. And if it turns out that EPA concludes the endangerment finding should be reversed, and therefore there is no basis to regulate greenhouse gases under the Federal Clean Air Act, there's a great deal of concern that that decision may either result in a loss of arguments that the Clean Air Act has displaced federal common law under federal tort claim lawsuits alleging climate damages against fuel producers. In addition as well, it may undermine preemption arguments that the Clean Air Act preempts consistent state tort laws that would impose liability. So there's a fine line that will have to be navigated. And then whatever happens will undoubtedly be subject to extensive, vigorous litigation. And then last, the Congressional Review Act is being deployed in innovative ways. In particular, it's being used to attack two different kinds of agency actions. One, EPA has requested that California's fuel waiver, which it's allowed to under the Clean Air Act, where it can request more stringent fuel regulations, emissions regulations on cars sold in California. They have, the agency has been tasked with whether or not to reconsider and revoke that California waiver determination, which is made by the Biden administration before it left office. That would involve going through the full process of rulemaking and comments and final rule and then litigation. As a way to short circuit that process, EPA has instead has determined that it is a final agency action, a major federal action that can be trigger Congressional Review Act review by Congress. The Congressional Review Act essentially gives Congress the ability to override a major agency rule if it finds that in a pursuant to a joint resolution by both the House and the Senate, most importantly, without a filibuster in the Senate. So as a result, at this point, there's the Congress has not yet picked up the California waiver submittal, but there's a joint resolution working its way through the system. In addition, the same way, the EPA Biden administration's rule to impose essentially penalties for excess methane emissions of oil and gas production, also at the same time, has been subjected for congressional act review, and that one has actually already received a vote from the House and the Senate to revoke the rule. President Trump only needs to sign that joint resolution. If he signs it, or alternatively, in addition, if President Trump receives a joint resolution from both houses and signs the California waiver revocation as a congressional review action, that statute under the Congressional Review Act provides that it basically salts the earth. The agency will not be able to pass a similar rule. That's going to be very interesting and problematic because, for one, the methane fee rule was pursuant to congressional legislation, the Inflation Reduction Act. So EPA will have a duty to pass a rule, but they will be instructed by the Congressional Review Act they can't pass the same rule that Congress rejected. So it's a little bit undefined territory. And it's never been used to revoke a waiver. The GAO had already previously said that doing that with a waiver was not subject to review in the Congressional Review Act. So these four alone are going to be critical issues in defining the scope of executive power over climate policy and its interrelationship with congressional authorities. So before time runs out, I wanted to offer one quick parting thought, which is you'll notice there's a lot of new tactics and tools being used here. The standard default traditional approach is that if the new administration wanted to change the rules, they had to go through rulemaking, which meant that you had to go through the notice and comment, proposed rule, you'd get the comments, you respond to them, you put the final rule, you'd be litigated, and you'd be lucky if you got through the entire process before the end of that term. This new approach is really kind of a post-administrative state approach, where essentially you're invoking a whole suite of different tools and new ways to essentially short-circuit the process. If the Congressional Review Act and the budget reconciliation process, which also bypasses the filibuster, give you a window of time to make changes without having to go through full filibuster-proof review. Emergency authorities and powers give the ability of the president to take direct action and rededicate funds. And alternative administrative processes like direct final rules, such as CEQ's revocation of its NEPA rules, or enforcement discretion, like the Trump administration promising not to enforce the TikTok ban, offer an alternative to traditional rulemaking, in addition to, of course, President Trump's full panoply of Article 2 powers. Put all those together, and what you have is a way to essentially jumpstart sweeping change in a way that may not stick, but that may not matter, simply because once you've got a new status quo, it's possible to get different types of essentially legislative ratification after the fact, or other types of enforcement tools that let you memorialize and set in some form of administrative concrete some of these new changes, the new reality. So with that in mind, climate's the harbinger. It's what we may be seeing for future administrations who want to basically take the process and move it along much, much more rapidly than the Administrative Procedure Act has traditionally allowed. And on that thought, I'll pass the microphone over to Professor Warren.
Thank you so much, Tracy. We're very glad to introduce Professor Gina Warren, who's going to be talking about energy. And remember to post your questions in the Q&A tab for the speakers. We can do that after the presentation. Thank you.
All right, everyone, you made it. I am the last presenter of the day, and so I'm going to do my best to keep you entertained. I really appreciate that you stayed on all of this time and are interested in what we have to say. So I really am looking forward to the conversation right after this. So my presentation will focus on energy and permitting and environmental justice initiatives. So first, we want to look at the what the administration is favoring for energy sources, how they're looking to streamline the permitting of some of those favored sources, and then some of the implications of discontinuance of environmental justice initiatives and programs. So favored energy sources. So just to set the tone, right, and the other, Dean Burke and Professor Hester also mentioned this, is that on the first day, new administration set a tone as to what they were looking for in the new energy makeup in the United States. And so there were two executive orders that were put into place, the declaring a national energy emergency and unleashing American energy. And in both of those, we get a really good flavor of what it is that the administration is looking for. And so, so basically you have the encouragement through their definitions of development of fossil fuels. Also, though, encouragement of development of nuclear and hydropower. So in the declaring national energy emergency executive order, there was the definition of energy, including fossil fuels, right? So you see all the fossil fuels, but you also have uranium, so nuclear, coal, biofuels, geothermal, and hydropower. So hydropower is starting to come back into potential play. So you're starting to see nuclear energy sources and hydropower energy that are both, carbon neutral, that may be a big part of this new administration's plan. And then you have Unleashing American Energy here that that also has the language that they want to prevent any undue burden on developing natural resources that are oil, gas, coal, hydropower, nuclear. So, so we're starting to see that this is what the administration will be favoring. And I think that it's important that when we see this, we're like, okay, well, what does that mean? And what does that mean for our current energy consumption? And so this is our current energy consumption in the United States of 2023, which is the latest results that we could get. And you can see that we have 38% petroleum, 36% natural gas, 9% coal, and then you have about 9% of each nuclear and renewables. And you can see that the main current renewable energy making up our renewables is wind. But taking a step back for a minute, I'd like to compare this. And so I started teaching in 2010. And so it's always fun to compare where we are now with where we were, nearly 15 years ago. And so if you look at this, what has changed? Natural gas has increased, right? Petroleum has stayed the same, gone up 1%. Coal is what has decreased, and that's because natural gas has taken over that number. And then look at this. So renewables have increased 1%. Now there is the shift in renewables from hydropower making up the bulk of that to historically to now solar and wind being ahead of them. But what I want to point out, and what might not be always obvious, is that we're still talking about 83% fossil fuels. We were 83% fossil fuels in 2010. We're 83% fossil fuels in 2023. And so when you see that there is this drill, baby, drill, as Dean Burke put it, we do see that. We are understanding that that's the desire of the administration, but it's also been very consistent that we've had 83% fossil fuels for a very long time. And so that we'll see if it makes a difference as to whether we actually increase our percentage of fossil fuels or not. But one of the things that's also come out of this is that there is a disfavored energy source that seems to be coming out, and that's wind. So there are a couple of provisions and a couple of memo and executive orders that are putting some prohibitions on wind on federal leasing and offshore leasing. And so you see this one, temporary withdrawal of offshore. So this is anything that's being developed depending on where you are, 3 to 12 miles off the shore. But so a withdrawal of that. And then you also see a withdrawal of wind projects shall not issue or renew approvals, permits, all of those things for onshore or offshore. And so wind seems to be a target. And but what's interesting about wind is that wind has been on this major kick lately. So we have about 150,500 megawatts of land-based wind in the United States that's powering about 50 million homes. And so in 2023 alone, we added almost 6,500 megawatts of wind and invested almost $11 billion in that industry. And Texas was leading that charge. Illinois and other states were increasing their wind generation. And the important thing to point out is that the majority of that, vast majority of that, in the 90-some percentile, or 90-some percentage, is being developed on private lands, so not being developed on federal lands. And so the majority of the wind production and generation in the United States is on private lands or state lands, not in the federal realm. In addition to that, targeting offshore is kind of interesting to me because we don't have any. So we have 30 megawatts that was the initial Block Island here off of Massachusetts. And then you have the South Fork Wind, which was 132 megawatts. The only one that was starting to produce anything and was in a phase of having like partially complete is this 800 megawatt of Vineyard Wind in the Nantucket Sound. And so we're not leaders in offshore wind. So this would be what's potentially in the federal waters. And then in addition to that, only 2 of these projects were actually in federal waters anyway. So so the implications of stopping offshore wind, it's interesting from a perspective of seeing it through the years, is that it really hasn't ever gotten started to begin with. So and then the last thing that's happening with the preference is that there was this pause on disbursement of funds. And those are funds that are coming through the Inflation Reduction Act. And those are targeting renewables, but it's not quite clear everything that's been targeted. They talk about terminating the New Green Deal, but the New Green Deal is not a defined term anywhere. So it's not quite clear to me as to exactly what the implication of this will be, and whether the production tax credits and investment tax credits will continue, which seems like likely they will. All right. So the next thing that I wanted to talk about was streamlining permitting. And so we have a couple of different provisions that have been put into place that with the goal of streamlining a permitting process. So you have the first one, establishing the National Energy Dominance Council. And this is a council intended to work with all the agencies to figure out a way to streamline and ensure that America is energy dominant. And again, you'll see the list of the types of energy resources that are being promoted and desiring to be streamlined. And then you have the declaring a national energy emergency executive order that directs, as Professor Hester said, directs the agencies to use their emergency authorities to accelerate it. This one is a little more generic. It says infrastructure, energy, environmental, and natural resources projects. So it's a little more generic. And then, as this was discussed a couple of times, is that another thing that was the goal was to remove CEQ NEPA assessments from federal permitting. And so that was under the Unleashing American Energy, executive order. And then we see that they actually did do that. So that was effective. It will be effective April 11th if it proceeds. And the implication for this is it's going to remove climate and environmental justice assessments that the CEQ was putting into place. And so I've seen a lot of discussions and presentations about the timeline, how long it takes to permit, and the numbers are all over the place. So, but when we're thinking about federal land, so doing something on a federal permit that's requiring a NEPA analysis, which is the only time you trigger NEPA analysis is if you need a federal action. There was a study that was done just recently by Utah State that said that the average is about 3 years, and then it gives you like the pages and everything. The interesting thing to me was that it was saying that hydropower was about 5 years. It likely is even greater than that if you were trying to license a new facility. Another thing to keep in mind is that nuclear is also federal. So trying to streamline that, which nuclear can take a very long time, decade to license. And then other things to think about are pipelines that you might need for increased oil and gas development, and then transmission lines. And depending on who's complaining and how much litigation is going on, each of those can take a very long time to license and to permit. And so, but the question is whether any of this will actually make a difference and whether it will benefit only fossil fuels, or will it benefit, could it potentially benefit other renewable projects as well? But, and we can talk about this more in the Q&A if you're interested, but it's about whether you're permitting something on federal lands or on state lands. So the last thing I want to say and end with is that another major impact that could happen is that so Professor Hester talked about removing all the climate analysis, but also removing environmental justice initiatives and programs. And so we had historically 2 environmental justice initiatives, so in a big category of those. So we have a Clinton era executive order that directed federal agencies to develop environmental justice into their plans to address disproportionate adverse environmental impacts on minorities and low-income populations. And then you had in 2022 a Justice 40 initiative with the goal of delivering 40% of the federal investment benefits to disadvantaged communities. And so both of these executive orders were revoked, and the administration went further than that by saying, not only were those revoked, but we're not going to allow you to talk about anything that would be considered discrimination. And so we have a executive order that directs federal agencies to terminate any kind of environmental justice initiatives, including programs and plans and all of those. And so what this means is concerning for many of us. And so I'll just leave you with the concept that we know the facts suggest, the facts show that an individual's zip code is the strongest predictor of how long they will live. And in Houston, they've done studies, and it can be greater than 21 years difference between what part of town you live in. And we know that pollution kills more people than a lot of things, including gun violence and car accidents, and that minorities are exposed to 38% more polluted air than white Americans. And so when we take away provisions that are going to evaluate that as to where we're putting these energy facilities, we could be running up against increasing vulnerabilities across our cities. So that's what I have. This is a list of all the executive orders. Just wanted to put that in there. We'll post these. And so thank you.
Thank you so much, Professor Warren. Kindly invite the presenters to join back for the Q&A. And these were fabulous presentations. In fact, one of the questions a comment praising the presenters for, it's like the way they describe this bumpy ride. It's like, and with solid overviews and demystifying trends. So this is great, and we appreciate those comments. So there's a question that's related to, things that the 3 of you have spoken about in the Q&A. The question centers on the Supreme Court's decision in the San Francisco versus EPA case, on the authority to issue end result limitations. And it touches upon something that Professor Hester mentioned earlier today, how that might, I mean, it's like preempt the ability of state agencies, I mean, it's like to rule in those conditions, but also, I mean, it's like the future EPA, I mean, it's like this post-administrative state, what EPA or any other agency, what they could do, I mean, it's like to try to, I mean, it's like remedy or change policy courses, right? So I don't know if any of you wants to take on that, but I think it's a great question, I mean, to think through about the relationship between the agenda that the current government's taking, I mean, it's like, and whether or not litigation might help, I mean, it's like cement, I mean, it's like a path forward, right?
Well, a rush for the mic. I'll take a swing at it first, subject to being overruled and corrected by everyone else, because this is off the top of my head. But if the question, if I think I saw it in the chat box, is whether or not the San Francisco decision is going to end up having an impact on the scope of authority of state agencies to issue permits containing similar narrative terms, including particularly Texas. I think the answer will be frustrating, but I think it depends. If the agency that we're talking about, let's assume it's TCEQ in Texas, is resting its authority purely on the delegated program subject to EPA federal terminologies, then that change, especially if it's in court by reference, may be relevant. But it's not limited to that. The agency could also rely on its own inherent state authority. States are allowed to be more stringent than the federal level. So it doesn't necessarily automatically mean that if you have a change in the federal level, that the state permit terms under state law are automatically also going to be affected. So you have to kind of do a little detective work and see which it is. And then if it is a federal issue, to a certain extent, it's kind of up to the state whether or not they're going to want to take advantage of that change in this interpretation of the statute and how quickly they can do it. So you'll probably see some ripple effects, but I don't think this is not like Sackett. This is not like major questions doctrine. This is not Loper Bright. It's not anywhere near in that same category. But it is interesting, especially, I can't resist noting, having Justice Barrett joining the dissenters on an environmental case. Stay tuned.
Yeah, I could see that the states could be interested in enacting like some sort of state energy policy act if they haven't already, if they're looking to have more protections at the state level. There are many states that have those. And so given that most energy is developed on private lands within the state, those are usually what's governing anyway.
So a follow-up on that, I mean, it's like there are a couple of points that were raised, I mean, it's like in your presentations, and some are connected to this idea that Professor Hester put forward in terms of the new way of making policy. I mean, right? I mean, it's like the post-administrative state you're calling it, right? So can you see that these strategies might lead to force the hand of courts to make decisions that could have longer term impact, even under these uncertain times? I mean, it's like, is that something that would be part of the strategy? I mean, it's like throw things at the wall and see what sticks type of approach, or is it, I mean, it's like something else? I mean, it's like, and relatedly, I mean, it's like a follow-up. I mean, it's like how that might affect the uncertainty that Dean Burke talked about. I mean, it's like, right? And the positions that Professor Warren mentioned about how do we affect the choice of energy sources, right? I mean, it's like through these decisions, right? So I wanted to throw that at you. I mean, it's like probably a question for each.
Well,
I mean,
first last time, so I'll pass the mic
yeah,
on.
I think it's an interesting question. I guess, the role of the courts, we'll find out what that's going to be. I think, if I may, one of the things I think is the more important thing is the role of market for energy. I think it'll be, what does the market say? I think about if Texas is putting, billions of dollars into wind. Well, they're doing that because they think they can get a profit. They can make a profit, right? And so regardless of what the regulations are and regardless of what is being pushed, the industry is likely going to be seeking things that are financially viable for now and in the future. And one thing that you'll see is, I had a student ask me the other day, do you think that this means that the majors are now going to start going to develop new coal facilities? And I'm like, probably not, right? So you're getting a green light from an administration, but likely what we know is when we're really thinking about, 25 years into the future or whatever we're looking at, we're probably not thinking about developing more more fossil fuels. We're probably thinking about being more carbon thoughtful and environmentally thoughtful. So yes, the courts play a role. Yes, all of these things play a role. But I think what sometimes is missing in the conversation is the role of the market and the business side of things.
Absolutely. I think, and this goes to the next question in the Q&A, and they're asked if wind farms are on private land, what's the real effect of this executive order regarding wind energy? And I think, again, the market is going to drive. So the president and the executive branch, tremendous amount of power, cannot actually control the market. Right? Can do things to influence the market? Yes. But for example, we're in a global market, right? So for example, with OPEC making its decision about how much oil it's going to release into the market, right, will drive what kind of investment will occur in the United States for new activity, right? We'll continue with, for example, the wells that already exist. But that driving the price down makes that much less attractive investment. And then specifically with respect to wind, wind energy on federal land has run into so many difficulties that, the projects are moving slowly. And one thing, for example, that will probably have more of an impact than this actual order are the tariffs. Right, because the challenge with wind and solar, those things out west, is infrastructure, getting the power that's being generated from the source to the people, right? And so that'll actually have more of an impact, I think, than any of this with respect to, for example, that type of resource.
Right, and especially with, I'm sorry.
Go ahead. I'll just offer a great stuff when you're done.
So infrastructure, right? Transmission infrastructure has been stagnant and stagnated for a really long time, and we've been bottlenecked. And the Department of Energy and FERC have been working for years to try to figure out how to streamline this. And so there are a lot of different groups that would like to streamline more electricity or transmission, because it will also facilitate more renewables into the system, right? So it's going to help with any kind of energy infrastructure.
I'll just add that obviously Dean Burke and Professor Warren are absolutely correct. I agree. The market is going to be probably as important, or more likely more important, in terms of future development of wind and solar, simply because the cost curves seem to make it an important element, regardless of what the legal case might be. Circling back to the question about what role the courts might play, though, given this, I'll just simply say normally the courts would be, I think, an important player in checking the exercise of executive power in these novel ways. The problem is the courts themselves are in the middle of this testing of constitutional power. The power of district courts to issue nationwide or universal injunctions is going to be sorely tested immediately. The scope of injunctive relief just generally that a court has after federal statute's been passed is going to be tested immediately. A lot of these things that normally be just environmental questions like just standing are going to be unfortunately magnified in a big way because they're going to be pivotal for all the other constitutional challenges going on. And my suspicion is that the courts are going to be very cautious about picking their fights. We're going to see a lot of very careful scrutiny to standing, or a lot of careful scrutiny as to what the court can actually, relief it can actually grant. And as a result, we're going to see perhaps in a hypothetical world with all these other challenges not taking place, I think we might see a bit more of a diminished role of the courts. But the ones that they do pick their fights in will be particularly important.
This is great. We're running out of time, but we have 3 questions. In the Q&A. I'm gonna pick them up. I mean, and try to paraphrase so we can go faster. So the first one is that with the disassembling the federal administrative state, does that mean that since those powers are no longer at the state level, at the federal level, that the states might be able to take on some of those challenges and extend their own power? Locally. Right? So that's the first one. The second one is do we have a sense of how much taxpayer money is spent defending executive orders? Is that being captured? And the last one is that since the election and prior to any rifts, BSEE has already lost about 17% of its civil servants, something that Dean Burke has been mentioning more broadly for other agencies. So do we see that VSEE, VOEM, and BLM will be able to implement any rational national energy program, including drill, baby, drill?
I feel like we answered the first one decently well about what the roles of the state might be in this circumstance of the things they might try to do and some of the barriers that they might have. Taxpayer money, I have no idea. I don't know if either of you guys know that.
Well, my thought is that, Department of Justice lawyers and agency lawyers, that's sunk cost, right? What the real cost is that if they're defending these actions, they're not doing something else. All right. So I don't know that they're going to go out and hire a bunch more lawyers. That would be great for our law schools. But I think that it's really that they're going to have to make decisions about resources. And similarly, those that are suing are not going to be able to sue on every case that they think is problematic. It's a rationing of resources.
Yeah, I absolutely agree, but with a small caveat. I'm sure, all of us have been getting calls from students and former students who are suddenly no longer employed by the federal government, including DOJ, or have been told that they have to give up their remote locations and report back to duty in DC. The budget may be a sunk cost. The people, that is an asset that is rapidly getting disrupted right now. And I have no clue. Having this avalanche of executive orders to defend at the same time, you're reassigning senior DOJ personnel to do a sanctuary cities enforcement. Who knows?
Yeah.
And so
Go ahead.
I was just going to say, so the same issue with implementing some of the policies they want to implement. If you don't have the people to do that, that could certainly run into a problem.
And relatedly, we've seen the same issue with policy analysts, the people we are training, right? Where they just, as Dean Burke said before, they might not be willing to be considered the villains in these stories and not pursue those careers. And that's a big loss of human capital for areas that need it. So I think we're out of time. Thank you so much, Professor Warren, Dean Burke, Professor Hester. This was a fabulous, I really enjoyed the session and presentation. And hopefully there will be more of these conversations coming forward. Okay, I'll invite the rest of the panelists to come back. Don't leave us. I think we'll ask to stay longer. So we have Dean Granado and Dean Baines, and I'm gonna yield to them. There's a
Thank you.
last, yeah, there's a last
Thank you
question,
so-
Q&A, if somebody wants to answer. Thank you.
Okay, thank you. This was wonderful. Thank you, Professor Pinto, Professor Warren, Professor Hester, and Dean Burke. It was an illuminating conversation. Really appreciated it. And thank you all for coming. This is the end of our program. We had a lot of you sticking with us to the end, covering really important topics such as the economy and higher ed and immigration and now energy and environmental policy. So many thanks for us, all of you, all our panelists and all the panels for making this happen and informing our audience about these really important issues. And many thanks to my colleague, Dean Granado from the Hobby School of Public Affairs, where I'll turn it to him to have the last word. Dean Granado.
Just what you said. It's a pleasure working with you and your team, Dr. Baines. And again, to our panelists, great job. It was very illuminating.